Yes.
Your Ladyships and Your Lordship, I appear for the appellant, Mr Rahman, who is one of the two petitioners in the company claim in the court below. My own friend, Mr Wynne Smith, appears for Mr Munim and Le Chef plc, two respondents to the unfair prejudice petition in the court below. Mr Ahmed, who was the co-petitioner in the court below, does not appear and is not represented. You may have gathered that he appealed the decision himself by way of a separate appellant's notice. He was granted permission to appeal, but he then compromised his appeal.
Yes.
So there was an agreed order dismissing it without a determination of the merits.
Yes, yes, we're aware of that.
In respect of housekeeping, there were some additions to the core bundle. My learned friend solicitors sent to the court via email yesterday, I think, an amended index and some additional pages to go into the core bundle. The additional pages consist of the trial skeleton arguments. In respect of Mr Rahman and Mr Ahmed, there was a skeleton dealing solely with the company claim. In respect of Mr Munim and the Chef, there was a combined skeleton dealing with the company claim and the copyright claim. If they haven't made their way into the bundles, my learned friend solicitors have brought hard copies today of both the amended index and the additional pages, which I believe are on the court bench there. I don't know if they've been inserted into the court bundle.
And we have those, thank you. Thank you.
And so you should have a core bundle, a supplementary bundle, and a joint authorities bundle.
Yes. Just before we start, if it's of assistance, I think we've all had the opportunity of reading extensively into the documents of the case. Obviously, we've read the judgments and the skeleton arguments, and I think we've read all the relevant material in the core and supplementary.
Right, thank you. As you will have seen, this is an appeal that is solely appealing findings of fact. There was no dispute on the law in the court below, and the judge dealt with the law very briefly in the judgment at paragraphs 84 to 85 on page 67 of the court bundle. So it's an appeal against findings of fact, but in summary, the appellant's case is that the judge made findings of fact in this case that should be set aside because they were either made rejecting evidence that had not been challenged in cross-examination, or they were not supported by the pleadings in the case, or they ignored important evidence that had been put before the court, and or the decisions on the findings of fact were insufficiently reasoned. And I'll seek to make good that in the various grounds that I go through. In respect to the authorities, there are two authorities you will have seen that aren't referred to in our skeleton arguments on either side. Firstly is the Supreme Court decision in TUI and Griffiths, which came out in November last year, so that was after both sides had filed our respective skeleton arguments. So I'd like to just take you to that and perhaps highlight some passages from that. Another one is a Court of Appeal decision of Ali and Dink, where my Lord Justice Birss gave the substantive judgment, and that is an authority which considers and builds on one of the appellant's authorities, Al Medini and Mars UK, in respect of whether a judge has gone beyond the issues that were identified from the pleadings and or the evidence. Just by way of the facts, you've read in extensively, so I don't propose to say too much about them. Can I take it you've had a chance to read the handwriting evidence in full?
Yes, we all have.
Yes. So, well, just to summarise the facts as I say they are, this was a case primarily about signatures. Mr Ahmed and Mr Rahman both challenged the authenticity of signatures that it was said on behalf of Mr Munim were theirs. Primarily the stock transfer forms, that each of them denied that they had signed those documents, but also in the case of Mr Rahman, certain resolutions that were put forward stated to be signed by him, which were supportive of Mr Munim's case in the court below. So on the basis of that handwriting evidence was obtained, and it was clearly a crucial matter for the court to assess what signatures were authentic or not authentic. The judge described the signatures on the stock transfer forms as the first of the main factual issues which he had to deal with. The reference to that is paragraph 70 of his judgment, page 64 of the core bundle. And this really goes to ground one, which I'll come to, but in broad summary, in a case that was all about signatures, in my submission there's a remarkable lack of cross-examination of Mr Ahmed and Mr Rahman about the issue of the signatures. And that point perhaps takes me to TUI and Griffiths, the first of the two authorities that aren't referenced in the skeleton arguments, which appears at tab 1 of the Joint Authorities bundle.
Thank you.
And it addresses the scope of the long-standing rule that one must challenge evidence in cross-examination of witnesses whose evidence is challenged by the relevant party, traced back to the rule is said to arrive from a case of Brown and Dunn. This case concerned a failure to cross-examine an expert witness, but the principles are of general application, as is made clear by the single judgment of the Deputy President, Lord Hodge. I'd just like to highlight a few paragraphs from this. You should have highlighting, which is a combination of both my highlighted passages and Mr Wynne Smith. Paragraph 11 on page 8, a short passage highlighted, just to make clear that in that case, the criticisms that were made of an expert and their analysis of causation of an illness that the claimant suffered while on holiday were challenged by way of the skeleton argument served before trial. So the defendant did put forward to the court and to the other side before the trial started they were going to challenge this. That was not sufficient, though, to deal with this principle. There was then a discussion in the Supreme Court about exactly what the principle was, and Lord Hodge deals with it by reference to a passage from Fiction on Evidence, which you'll find in paragraph 42 on page 18 of the Authorities bundle. And paragraph 42 starts off with the proposition which is key to all of this, is that the task of the judge in conducting a trial in an adversarial system is to make sure that the trial is fair. The task of the judiciary in developing the common law and the makers of the procedural rules to formulate rules and procedures to that end. And then one such long-established rule is the rule that is set out in Fiction on Evidence and was quoted by Lord Justice Bean in the Court of Appeal in that case. And then it's set out there, in general, a party is required to challenge in cross-examination the evidence of any witness of the opposing party if he wishes to submit to the court that the evidence should not be accepted on that point. The rule applies in civil cases. In general, the CPR does not alter that position. This rule serves the important function of giving the witness the opportunity of explaining any contradiction or alleged problem with his evidence. If a party has decided not to cross-examine on a particular important point, he will be in difficulty in submitting that the evidence should be rejected. Paragraph 43 over the page, Lord Hodge says that he is satisfied the statement of Fiction is correct and is a long-standing rule of general application. And he notes that whilst many cases deal with challenges to the honesty of a witness, he sees no rational basis for confining the rule to such cases. He does set out examples of when the rule may not apply from paragraph 61 68, although in my submission none of those will be applicable. I note neither I or my learned friend have highlighted any of those passages for your attention. And then the conclusion is in paragraph 70 on pages 26 to 27, and various propositions are stated there. The general rule is stated in 70(1), and then a number of purposes of this rule or rationales are then set out. So little 2, it's to ensure the trial is fair. Little 3, it includes fairness both to the party who's adduced the evidence of a witness, but also fairness to the witness at little 4. And as well as fairness both to the party and the witness, little 5 makes clear that maintaining such fairness also includes enabling the judge to make a proper assessment of all the evidence to achieve justice in the case. The rule is directed to the integrity of the court process itself. As regards the fairness to the witness, little 6 explains that cross-examination gives the witness the opportunity to explain or clarify his or her evidence. That opportunity is particularly important when the opposing party intends to accuse the witness of dishonesty. There is no principled basis for confining the rule to cases of dishonesty. And little 7 does make the point that it's not an inflexible rule and there may be some relaxation in certain circumstances. And by way of example, around 4 lines from the end of little 7, thus where it will be disproportionate to cross-examine at length, or where, as in Chen and the trial judge has set a limit on the time for cross-examination, those circumstances will be relevant considerations in the court's decision on the application of the rule. So it is a clear rule, I say, which serves multiple purposes: fairness to the trial judge, to the witness, and to the party relying on the witness. Whilst it's not inflexible, I ask the court to note there, in my submission, there needs to be some reason why it should be disapplied. So it may be lack of time. It might be it's considered a peripheral point that doesn't really go to the crux of the case. And in an extensive cross-examination, one wouldn't need to deal with that, or one could be excused dealing with that. But absent some justification for departing from the general rule, in my submission, one should comply with this. And that will form much of my argument on ground 1 when I come to that. Another case which deals with this point in a slightly different way is Chen and Ng, a Privy Council case at tab 5 of the authorities bundle. It is referred to as one of the authorities considered in TUI and Griffiths. In my submission, this is essentially an extension, one might call it, to the general rule. And I'll explain in a moment why that is, but this was a dispute about beneficial ownership of shares in a BVI company. Mr. Ng had executed an instrument of transfer to transfer his shares to Madam Chen, the claimant. His case and his evidence was that it was on the express understanding she would transfer the shares back to him 6 months later. And the judge rejected his evidence, giving 2 reasons for doing so, which are set out at paragraph 48 on page 100. Around 5 lines down, it says on 2 grounds, and it says the first was that the explanation which Mr. Ng gave for this arrangement was unconvincing, as it would have been self-evidently futile to expect the Macau and Beijing authorities to believe that Mr. Ng had no involvement in the proposed development. The second ground, which appears to the board to be and to have been regarded by the judge as being of less weight, was that if Mr. Ng's explanation had been true, the judge considered that he would have obtained a transfer in blank executed by Madam Chen so that he could have ensured that the shares were transferred back to him. These 2 reasons for not believing Mr. Ng were not inherently objectionable, as is made clear at the start of paragraph 49. So there's nothing in principle wrong with those reasons, but the basis of the challenge on the appeal, which one can see summarised on page 101, the highlighted text starting in paragraph 50. Firstly, it explains that the judge made the findings of primary fact about Mr. Ng's credibility and case based on reading his lengthy written material and seeing him in the witness box for 1.5 days in the context of the material before him as a whole. Ultimately, however, he expressed only 2 reasons for rejecting Mr. Ng's evidence, so that it is on them the appeal in this area must focus. It again makes the point they're not unreasonable, unjustified reasons in themselves. But the argument at paragraph 51 is that if those 2 grounds cited by the judge were to be relied on as reasons for disbelieving Mr. Ng, they ought to have been put to Mr. Ng in argument, in cross-examination. And if neither was raised with him, then it was unfair to him for the judge to have relied on either of them as a reason for disbelieving him. And accordingly, it would be wrong to let the decision of the judge stand. And paragraph 52 explains that in a perfect world, any ground for doubting a witness should be put to the witness, and a judge should only rely on the ground for disbelieving the witness, which that witness has had an opportunity of explaining. It goes on to say the world is not perfect, and there may be situations where one cannot have this standard of perfection. At paragraph 54 over the page on 102, having described the rule starting from the case of Brown and Dunn of challenging a witness's evidence, it explains, paragraph 54, that the judge's rejection of Mr Ng's evidence and his reasons for rejecting that evidence do not infringe this general rule, because it was clear from the inception of the incident proceedings and throughout the trial that Mr Ng's evidence as to the basis on which the shares were transferred in October 2011 was rejected by Madam Chen. Indeed, Mr Ng was cross-examined on the basis that he was not telling the truth about the issue. So he's actually been challenged on this particular issue, but as explained, it's a more nuanced challenge than that. It's that the grounds for disbelieving him on the issue on which he was challenged were not put to him. And then it's a question of whether that is fair for the judge to then rely on those reasons as a basis for disbelieving him. Paragraph 55 talks about a high level of generality in cases such as this, where the court considers two conflicting principles: the need for finality and minimising costs in litigation on the one hand, and the even more important requirement of a fair trial on the other. And there are a number of factors listed there in paragraph 55 as to trying to weigh up those competing considerations. At paragraph 57, the conclusion in this case is that it would not be fair to let the rejection of Mr Ng's evidence stand, given that the two grounds upon which the judge reached his decision were not put to Mr Ng. And a key point, it seems, in this case was that the ultimate factual dispute between the parties in the litigation was the basis upon which and the circumstances in which the transfer of the shares took place, and therefore the issue on which Mr Ng was disbelieved was central to the proceedings. It makes the point, 58 highlighted, that the two grounds were not by any means obscure. Later highlighted both could very easily, in the course of a 90-minute cross-examination, have been put to Mr Ng. And at paragraph 60, it explains that it's not hard to conceive of answers which might have been available to Mr Ng to answer the first ground, and which might have satisfied or at least mitigated the judge's concern. And it even makes the point that Mr Ng had dealt with the second point in his witness statement, but it was not impossible that he might have had more to say about it if it had been raised in cross-examination. And in conclusion, they decided that the decision could not stand and there would have to be a retrial. So what I say we can draw from these is that the principle is to fairness to both the party and the witness. Firstly, if a judge is going to reject the evidence of a witness, it must be challenged in cross-examination. But further beyond that, the reasons for rejecting it that are to be relied on also need to be put to the witness as a general point, albeit one can look at the extent of the cross-examination, how close to the key issues the relevant point was in the case, and still make an assessment of whether the finding can stand in light of those considerations. The other authority that we haven't referred to in the skeletons is Ali and Dink. That follows on from an authority I have relied on, Al-Madani and Mars UK. Both of these, in my submission, concern a slightly different topic. These are considering the fairness of judicial findings that go beyond the issues in the case. Al-Madani, which is at tab 7, was a claim for injuries at work by a factory worker who unfortunately was injured when a real wrapping fell on her. And she claimed that a particular employee had put that in an unsafe position. The defendant denied that and said that the claimant herself had put it in that unsafe position. In that case, the judge raised in opening argument what was then termed the third man theory. The judge said, well, it's possible that it was neither her nor the identified employee, it was one of the other employees present. However, despite it being raised in opening, it was not explored in the evidence. Nevertheless, the claimant's counsel did adopt it in closing as an alternative argument, Just briefly, one can see page 135 of the authorities bundle. Paragraph 19, Lord Justice Dyson concludes, "I am in no doubt that the particular claim did not plead the third man theory." So this was a case where it was an unpleaded point. And paragraph 21 on page 136 says that in my view, the judge was not entitled to find for the claimant on the basis of the third man theory. It is fundamental to our adversarial system of justice that the parties should clearly identify the issues that arise in the litigation, so that each has the opportunity of responding to the points made by the other. The function of the judge is to adjudicate on those issues alone. And the last 4.5 lines makes the point that one consequence of this may be that the judge is compelled to reject a claim on the basis on which it is advanced, although he or she is of the opinion that it would have succeeded if it had been advanced on a different basis. Such an outcome may be unattractive, but any other approach leads to uncertainty and potentially real unfairness. Paragraph 22 makes the point the starting point must always be the pleadings. And in that case, it was concluded that the judgment was impermissible because the third man theory was not pleaded and it was not explored in the evidence. And the fact that it may have been raised by the judge in opening and it may even have been relied upon in closings was insufficient to deal with that defect. So the authority that then we haven't referred to in the skeletons is Ali and Dink, which was a challenge based essentially on the reasoning in al-Madani. So it was put by the appellant, but in that case the challenge failed. And my Lord Justice Birss dealt with the law, page 35, highlighted paragraphs 19 through to 26, I think. So there was a consideration of al-Madani and other authorities. And there was an addition of some further points of principle, paragraph 25 to 26, where paragraph 25 on page 37, my Lord made the point that these problems are concerned with the interest of justice and in particular with circumstances which are called prejudice to the losing party. The common sort of prejudice which is to be avoided is that the new point has arisen in such a way that the losing party was not given a proper chance to call evidence or ask questions which could have addressed it. And then my Lord goes on to talk about the function formed by pleadings, list of issues, and so forth. Over the page, again in paragraph 25, 4 lines from the bottom, my Lord says, by placing the emphasis on prejudice, the point I'm making is that the modern approach to the definition of the issues requires judges to adopt a pragmatic approach in line with the overall objective and not to seek to be governed by unnecessary formality, provided always that it is just not to do so. And in that case, my Lord came up with essentially a 3-stage test at paragraph 26 to decide the appeal. The first stage is to identify what case or cases the parties are advancing. Second, to compare that with the decision the judge made. And third, if need be, to identify what prejudice, if any, may have been caused to the defendants. And the challenge in that case failed because it seems to have been the other end of the spectrum from al-Madani. Paragraph 30, my Lord explained that the conclusions of the judge were composed entirely of the acceptance or rejection of factual assertions which were pleaded. So it's not like al-Madani, a case where it was outside the parties' pleaded case. And it does also appear that it was dealt with in evidence. And at paragraph 34, in summary, my Lord explains that the case was argued out fully by counsel before the judge. In no case could it be said the appellants were ambushed or precluded from advancing submissions or evidence which they might otherwise have done. And the appellants have not identified any step they might have taken but were deprived of the opportunity to take because of the way the case was decided. No evidence being identified which the appellants might have called but did not, nor any questions which might have been asked in cross-examination, nor any authority which might have been cited. No prejudice to the appellants of any sort has been identified. So, in my submission, these are two extremes of a spectrum. Al-Madani is a situation where a case is unpleaded and untested in evidence, and Ali and Dink is a case where the factual assertions were pleaded, they were canvassed in evidence, they were fully argued out, and no prejudice could be identified. And there may be cases in the middle where the court will have to make an assessment as to how far it is towards one side or the other, as to where there's unfairness in the way the judge has decided the case. That's all I wanted to say on the law. Hopefully I haven't gone through it in too much detail for the court.
That's most helpful, thank you.
So, turning to ground one, this challenges the judge's findings of fact on the issue of signing the stock transfer forms. And the appellant challenges both the finding in relation to Mr Rahman, but also the finding in relation to Mr Ahmed. And in my submission, the finding in relation to Mr Ahmed's signature on the stock transfer forms is relevant to the signature of Mr Rahman. Both of them said that their signatures were not their signatures on the stock transfer forms. Mr Munim, in his case, said that he had discussed matters with Mr Rahman. Mr Rahman had told him that he had spoken to Mr Ahmed and they had both agreed to transfer shares to Mr Munim. Mr Ahmed and Mr Rahman both were consistent in their evidence. They did not have these discussions, they did not reach these agreements. So there's an overlap between Mr Ahmed's case and Mr Rahman's case. In my submission, if the judge reached the conclusion that Mr Ahmed had forged, Mr Ahmed's signatures on the stock transfer forms were forged, then he must factor that into the decision of whether Mr Rahman's signatures were similarly forged. And the judge recognises the degree of overlap in his judgment. So if we just go to the core bundle, page 64, he deals with the finding of fact in relation to the share transfer form starting at paragraph 70, which he describes as one of the main issues. Paragraph 71, he makes the point that the expert evidence in respect to Mr Ahmed, the expert concluded that there was no pictorial similarity between that and the specimen signatures, and therefore it's not possible to carry out a usual comparison because of the difference in styles. He goes on to explain in a bit more detail as to what the expert says, and then the point is, at paragraph 72, he says that uncertainty does have some impact upon whether this signature of Mr Rahman is genuine. So the judge recognises that uncertainty as to Mr Ahmed's signature has to be factored into the question of whether Mr Rahman signed his own stock transfer form, the one attributed to him. So my starting point in my submission is one cannot separate these two out and assess each in a vacuum. They are interrelated. The judge was right to recognise he could not deal with them entirely independently, and he did not attempt to do so. He recognised that one had an impact on the other. I'd like to start with my challenge to the judge's finding on Mr Ahmed's signature. His finding in relation to that in his explanation of his conclusions is at paragraph 75 to 76. Sorry, 76 to 77, my apologies, on page 65. So having reached a conclusion that Mr Ahmed did sign the forms, 76, Mr Ahmed must be considered separately. In my judgment, he gave his evidence in an entirely straightforward and impressive way. He appeared to be genuine in saying that he had not signed the share transfer form or agreed to give away all of his shareholding. In my judgment, it's unlikely that he signed the forms in a different style in order to deny it later. Just on that point, whether he'd signed it in a different style to deny it later, you may have seen in the grounds, one point stated there is that this is inconsistent with his finding that Mr Rahman actually signed the forms. I didn't draft that part of the grounds, and I don't rely on that. I don't submit that this is inconsistent with his finding that Mr Ahmed signed them. It's just his rejection of one possible way in which they could have been signed. So he rejected the idea that Mr Ahmed had signed it in a different style in order to deny it later.
Sorry, could you just clarify what part of the grounds, exactly what part of the grounds you're not relying on?
Yes, so if I take you to the grounds of appeal in the core bundle at page 16. So ground 1A at the top of page 16 has two sentences, and it's the second of those sentences that I don't rely on.
Thank you.
So I do seek to demonstrate there's no evidential basis to conclude that stock transfer forms have been signed either by Mr Ahmed or on his behalf, but I don't seek to say it's contrary to that particular finding that Mr Ahmed didn't sign it in an inauthentic style to deny it later. Going back to page 65, paragraph 76, he said, I accept to some extent that the reason he did nothing after his November 2014 emails to engage with Mr Munim or the chef was that he thought Mr Rahman was dealing matters on his behalf. On the other hand, it's somewhat surprising that there was not one inquiry thereafter of them as to his shareholding, if that is what he believed he retained. And then the key point which I wish to come to now in my submissions is whether he signed in a different style simply because he has an alternative, or Mr Rahman signed on his behalf and with his authority as he was then in the USA. I am satisfied in the circumstances set out above that the forms were signed by him or on his behalf. And then he says it's likely over the years in which he has had no further engagement with the chef, he has forgotten this, and that on seeing the signature on the forms and having liaised with Mr Rahman about the circumstances, he's convinced himself that he did not sign or agree to the transfer. So his finding is that the forms were either signed by Mr Rahman or on his behalf. If they were signed by him, they must have been signed in a different style. As you would have seen from the expert evidence, the signature was nothing like the specimens provided by Mr Ahmed. And I say that neither of those two options can be maintained as a basis for the finding of the judge. Dealing with the different style point, if we look at the supplementary bundle, page 68. I'm not sure if the court has tabs in the bundle. Mine is just printed off, so I don't have any tabs. I don't know whether the hard copy...
No, we don't either.
You don't? Okay. Well, it's page 68. So this is the latter part of Mr Ahmed's witness statement for trial. Paragraph 19, he says, I have seen two stock transfer forms dated 31st of October 2014, purportedly signed by myself. I can confirm that these are not my signatures. He then attaches them. 20, furthermore, at the time of the alleged signature, I was in the USA. So he makes a clear statement, he did not sign these. These are not his signatures. This was simply not challenged in cross-examination. The high point of the cross-examination in my submission can be found on page 270 of the supplementary bundle. So this is my learned friend cross-examining Mr Ahmed. At the bottom of page 270, below G, there's a question, and I'm suggesting that shortly after this, because there was a change of heart about what might happen with your involvement, you then confirmed to Mr Rahman to go ahead with the stock transfer form, and you gave your agreement that your shares would be transferred. And the answer is that's false, that's wrong. One point to make is it's actually two issues rolled up into one question. Firstly, confirming to go ahead with stock transfer forms. Secondly, giving agreement to a transfer of shares. So the compound question, it's not entirely fair to the witness as to what exactly he's answering. But if we look at the first part of that, you then confirm to Mr Rahman to go ahead with the stock transfer form. That is not, in my submission, any proper challenge of his evidence that I did not sign this form, that is not my signature. If that's to be challenged and it's to be suggested that he signed it himself, then it should be put to him. Now, given the expert had raised the possibility of there being an alternative style, and the expert had said the quite obvious point that this doesn't look like any of the specimen signatures of Mr Ahmed. In my submission, it's quite remarkable that there was no cross-examination or questions from the judge to Mr Ahmed about whether he had an alternative style of signature. Simply wasn't raised with him at all. He wasn't asked about whether he'd signed the stock transfer form. He wasn't taken to the document. He wasn't shown the form and asked about the signature on it. So in my submission, the judge's suggestion in his judgment that Mr Ahmed may have signed in an alternative style that nobody's so far seen in this trial process cannot stand.
But it's not a finding, is it? It's a suggestion.
Well,
he doesn't find, put it this way, he doesn't find that Mr Ahmed signed in an alternative style.
Well, his finding is essentially one of two things must have happened, it seems. Either he signed an alternative style or Mr Rahman signed his behalf. And what I'm going to suggest, what I'm going to submit, is that neither of those were open to the judge as a finding. He had to reject the alternative style, and for reasons I'll come to, he would have to reject the suggestion that Mr Rahman had signed it on behalf of Mr Ahmed. And if he can't rely on either of those, then he can't reach a conclusion that it must have been either signed by him or on his behalf. So, as he hasn't picked one of the two, I intend to attack each one individually and show why neither could be a fair justification for a finding that this stock transfer form had been signed by Mr Ahmed or with his authority. If the judge had picked one, I would simply restrict myself to whichever one he picked, but he didn't. So,
I see.
So in my submission, he had to reject the possibility of a signature by Mr Ahmed with an alternative style. Firstly, I say it's unfair to Mr Ahmed and also to Mr Rahman, who's relying on his evidence as part of his case, to entertain that as a possibility where it hasn't been put to him that his clear evidence that he didn't sign it was wrong. It's not an obscure point. It's not a point that there was insufficient time to deal with. It's a clear point. If you're dealing with a case about signatures where somebody says, my signature's been forged, if you wish to say that that is your signature, you need to put it to them. You need to challenge that evidence in my submission. And it's unfair for the judge to entertain that as a possibility that he had an alternative style when none of this has been raised with the witness in his evidence. So firstly, it's a matter of fairness. Secondly, I say the suggestion in the judgment that he may have had an alternative style in the absence of it being dealt with in the evidence is mere speculation. And it's based on speculation in the expert's report. The expert says, essentially, I can't say what the position is. Possibly, he might have an alternative signature, but it's just speculating. And because it's not dealt with in the evidence at all, the judge can only speculate at that stage if the judge is going to place any reliance on that as a possibility. And just by way of a brief third point, it's not the strongest of the 3 points, that's why I put it last, but in my submission, the judge fails to explain how this occurred when Mr Ahmed was in the USA at the time, which is the point that Mr Ahmed makes in his statement. Now, I accept it's not impossible for a stock transfer form to be signed by him and to arrive in the UK when he's in America. It's possible, but he makes the point in his statement, I was in the USA at the time, that's not challenged, and there's no consideration or explanation in the judgment as to exactly how that worked, and there's no exploration of that in the evidence as to exactly how that worked. One might expect there to be some kind of paper trail if there were a sending of a document. It might have been by email, it might have been by post, but there's nothing in my submission to support that. So those are the 3 reasons I say that possibility had to be excluded by the judge. He had to exclude the alternative style because lack of cross-examination, mere speculation, and failure to explain how it happened in the USA. The second of the 2 options of the judge is that Mr Rahman signed on behalf of Mr Ahmed. Now, the first problem I say there is with that possibility is that it's not part of Mr Munim's pleaded case that Mr Rahman had signed on behalf of Mr Ahmed. I seek to make that good by directing you to the pleadings in the company claim. So if I can take you to the core bundle, page 114. So just by way of background, the way that this worked was that the Mr Rahman and Mr Ahmed did original points of claim on their petition. There were then original points of defence. Mr Ahmed and Mr Rahman then asked Part 18 questions and got responses before then doing amended points of claim and then amended points of defence. So this is after the initial statements of case. These questions were asked and answers were received. So if we go to the bottom of page 114, we see the petitioners make some requests for clarification. So, to signature of the petitioners, in order for the transfer to be made, a signature is required. 2.1 request. How was the signature of both petitioners, in particular the second petitioner, i.e. Mr Ahmed, was obtained? Answer. Mr Munim received the stock forms from Mr Rahman, who handed them to him in person at the chef's registered office. Mr Munim is not aware of the circumstances when and where and how Mr Rahman signed the form himself or procured the signature of Mr Ahmed. So, in my submission, that shows that the case put forward by Mr Munim and the chef was that Mr Ahmed had signed and his signature was procured. And this is repeated again if we look at page 115. Missing information in respect of first petitioner. 1. Where did this take place? Answer. Our client is not aware of where Mr Rahman and Mr Ahmed signed the forms. So, again, a suggestion there that Mr Ahmed signed some of the forms. The second set of questions in the bottom half of that box, in respect of second petitioner. Number 4. Who was present? Mr Munim is not aware in whose presence Mr Ahmed signed the stock forms. So he doesn't know about the presence, but again, his case, apparent from this, I say, is that his case is Mr Ahmed signed the form. He's not suggesting Mr Rahman could have signed it on behalf of Mr Ahmed. He's just suggesting Mr Rahman got the form. After this, Mr Ahmed and Mr Rahman amended their points of claim in light of the answers they got, and also a general desire to amend, I believe. I wasn't on trial counsel, as I think you probably gathered. So if we look at the amended points of claim at page 82 of the core bundle, and the key paragraph here is 19.3.
So what page?
Page 82, core bundle. Paragraph 19.3, nor is it accepted that the third party signed the stock transfer form dated 31st of October 2014 that is attached to the points of defence dated 8th of October 2020 as Exhibit 3. He has never seen this document until he had sight of the points of defence. Further, the signature on the document does not look like the third party's signature. The third party avers that his signature on this form must have been forged. So, the point here is that, so far as Mr Ahmed and Mr Rahman are concerned in their joint amended points of claim, they understand the assertion to be that Mr Ahmed had signed it, and they say he didn't, and his signature must have been forged. We then have the amended points of defence on behalf of Mr Munim and the chef. They start at page 93. If I can take you to page 97, paragraph 22b, the respondents pleaded the defendant and the third party executed stock transfer forms on or about 31st of October 2014 and transferred the relevant shareholding from the company to the claimant. My learned friend in his skeleton, I note, suggests that this pleading is wide enough to include the possibility that Mr Rahman executed the form on behalf of both of them. In my submission, it's not wide enough. It says clearly that the defendant and the third party executed stock transfer forms. And also, in light of the other parts of their pleadings that I referred you to, I say it's abundantly clear that the case for Mr Munim and the chef was that Mr Ahmed had signed his own form. I also rely on paragraph 28 on page 98. The second sentence, the defendant and third party well knew their shareholdings were no longer 25% and 10% respectively because of the agreement in late October 2014 and because of the fact they signed stock transfer forms. And then it makes a distinction in the case of the defendant, i.e. Mr Rahman, that he'd signed other documents, they said. Finally, on the pleadings, paragraph 33 on page 99, second sentence, stock transfer forms were executed by the defendant and the third party. So, in my submission, it's clear that the case pleaded on behalf of Mr Munim and the chef was that Mr Ahmed had signed his own stock transfer form. The second point I make on this is I say it wasn't explored in evidence that Mr Rahman might have executed a form on behalf of Mr Ahmed. I say it was not put to Mr Ahmed in cross-examination that he had authorised Mr Rahman to sign the stock transfer forms. I have referred the court to the cross-examination of Mr Ahmed. The reference was page 270 of the supplementary bundle. And you may recall I referred you to the assertion that Mr Ahmed had confirmed Mr Rahman could go ahead with the stock transfer forms. In my submission, that's wholly insufficient to suggest to a witness that he may have authorised Mr Rahman to sign on his behalf, to say that you confirmed he could go ahead with them, when the pleaded case on behalf of Mr Munim and the chef was that Mr Ahmed had signed them. That's insufficient to suggest to him you've authorised somebody to sign on your behalf. And also, it was not put to Mr Rahman that he could have signed the stock transfer form on behalf of Mr Ahmed in my submission. If we go to the supplementary bundle at page 144, this is an extract from Mr Rahman's trial witness statement. At paragraph 61, you'll see him say the claimant, a reference to Mr Munim, the claimant has since provided some documents relating to the alleged transfer of Rifat Ahmed and my shares. None of these share transfer documents were signed by me or Rifat Ahmed. So Mr Rahman's evidence is that in relation to all of the forms, whichever name they're in, he says he didn't sign any of them. Then if we look at his cross-examination on this topic, in my submission, a telling point is at page 242 of the transcript of the evidence. And if we look at just below A at the top of page 242, Mr Rahman is making some denial in the first answer, and the question is, just slow down on the denials until there's a question that makes sense to deny. I'm suggesting that shortly before the 1st November meeting, you were handed unsigned stock. And then Mr Rahman says, sorry, are we talking about which year? He tries to clarify the year. The year is clarified at 2014. So just to read that question, then on to the rest of the question starts, shortly before the 1st November meeting, you were handed unsigned stock transfer forms, which you were asked to sign and asked to have Rifat Ahmed sign, and that either at the meeting on the 1st November or shortly afterwards, you were reminded by Mr Munim that he would like those documents back, signed, and you said in response, I'm waiting for Rifat Ahmed's documents, and I'll give mine at the same time as his. Do you remember that's how it happened? Nothing like that whatsoever happened. And then it says, now at around that time we move on, so then there's a moving on to an email. One point I'd make about this is that this is a whole host of questions wrapped up in some extremely large compound question here as to a vast stream of events. So it's not really fair to the witness to try and get him to explain if he remembers how that happened, because there's various points he's actually been asked to deal with here. But within those various questions, what is said to him is that he said to Mr Munim, I'm waiting for Rifat Ahmed's documents and I'll give you mine at the same time as his. That suggestion that he had to wait for Mr Ahmed's documents is hardly compatible with the suggestion that actually Mr Ahmed authorised Mr Rahman to sign the document in his name. If he did that, he wouldn't be waiting for the documents. So I say as a conclusion, the suggestion in the judgment that Mr Rahman may have signed on Mr Ahmed's behalf cannot stand. Firstly, it's unfair to Mr Rahman as a party and Mr Ahmed as a party witness to suggest that Mr Rahman signed on Mr Ahmed's behalf without this being pleaded or tested in the evidence. The witness statements do not deal with the suggestion that Mr Rahman could have signed on behalf of Mr Ahmed. There was no ability to re-examine Mr Rahman or Mr Ahmed on this because they weren't cross-examined on it in the first place, so it didn't arise as an issue in the evidence. In my submission, this is very much at the Al-Madani stage of the spectrum between Al-Madani and Ali and Dink that I referred to earlier. This is a case where it's unpleaded allegations, untested in evidence, so therefore it's unfair to suggest in the judgment that this is one possibility of how actually this occurred. Secondly, the same point I made earlier in relation to whether Mr Ahmed could have signed in a different style, I say this is mere speculation. If it's not pleaded and not tested in the evidence that Mr Rahman could have signed with authority of Mr Ahmed, it's mere speculation for the judge to say, well, this is one thing that might have happened. It has no evidential foundation in my submission. I'd just like to deal with a point in the openings which my old friend has referred to in his skeleton, which you'll find at page 162 of the supplementary bundle. So after the case had been opened on behalf of Mr Rahman and Mr Ahmed by Miss Wanagat, Mr Wynne Smith then followed that up, one can see at 162B, and he explains that it's very fact sensitive on the petition. And he says, third line down, 2 words to the end, and it's important because it's not solely an issue as to whether particular stock transfer forms were signed, although it is of course an important component, because as the way it's put by Mr Munim very clearly, and it's accepted, that if there was an underlying agreement, but this was merely there's merely a technical infringement, because the stock transfer form was signed by somebody else, perhaps on behalf of Rifat Ahmed, but it was nevertheless in accordance with underlying agreement, then it's the respondent's, the petitioner's case that doesn't matter, because it could be taken simply as the parties are agreeing to amend the Articles of Association to make it work. So my learned friend relies on his reference to perhaps it was signed on behalf of Rifat Ahmed, and yes, he does mention that. But the point I'd make is that he's not saying that Mr Munim's case, that it was signed by Mr Rahman on behalf of Mr Ahmed. He's merely suggesting in passing that if it was signed by somebody else, and therefore it could not be relied upon as showing that Mr Ahmed had agreed to the transfer of his shares, the case for Mr Munim and the chef would be, well, actually, if there's an underlying agreement, we can effectively get over the technicalities of signing forms, and we can say that the underlying agreement was agreed between all the shareholders and would take effect under the duomatic principle, and one wouldn't need to go through the formalities of the transfer forms.
But the judge made no findings about that.
No, he didn't go on to that, which is the point I was going to come to later, that once he finds that the forms have been signed, he effectively treats that as the end of the inquiry. He decides he doesn't need to go into what he would have found had he decided they hadn't been signed. And if he did go into that, he would need to deal with whether there was unanimous consent to a change of the Articles of Association to allow for the share transfer, which is what I understand my friend's case was. Even if we can't prove that transfer forms were signed, there was a unanimous agreement of shareholders to allow the transfer, that would have to take effect as an alteration of the Articles of Association to allow that to occur. And as I understand it, because there was no express agreement, it would be inferred from conduct. So the judge would have had to decide, if the judge said, I find they weren't signed by these parties, he would have to decide, well, what was the conduct on behalf of Mr Munim, Mr Rahman and Mr Ahmed, all as individual parties, what was their conduct that showed unanimous agreement between the three of them to an alteration of the articles? Because it wouldn't be sufficient, just a number of them to agree to this. For the geometric principle to apply, it needs to be unanimous consent. The judge didn't deal with that, so if I'm right in my submission that he wasn't entitled to make any findings as to the signatures, we don't have any findings then to fall back on to say, well, he would have decided it the same anyway. That's my submission. I'd also make the point that if he found that the signatures were forged, that's a highly material factor to take into account in all of his other findings as to whether there was an underlying agreement, whether there was consent to change the articles. So if my submission is correct that his findings as a signature cannot be sustained, in my submission it infects everything else within his analysis on the whole case and all of his judgment, and it all needs to be set aside.
If the judge, I don't want to take up too much time, but if the judge had, instead of expressing himself the way he had, said, I find that Mr Ahmed didn't sign the document. I don't know how it was signed. It could have been, for the reasons he gave, he says, expressly in his judgment, two possible reasons are X and Y, but imagine he was prescient and imagine your submission and said, but I'm not going to make those findings, but I record those as two possibilities. He might have thought of some more, I don't know. If he'd done that, what difference, how would that help your appeal in this case?
Well,
just on behalf of Mr Rahman, not Mr Ahmed.
Well, so if he concludes I can't be satisfied that Mr Ahmed signed it himself, I can't be satisfied that it was signed on his behalf with his authority, somebody has signed it without his authority. In my submission, he then needs to reconsider Mr Ahmed's evidence, which he said was clear and credible. He said that he must have forgotten that he'd agreed to transfer away all his shares, but he actually regarded him as a credible witness. Mr Ahmed's position is that I've never agreed to this. These are not my signatures. They must have been forged. He would need to reanalyse that. Sorry.
I was going to say I could understand if you were appearing for Mr Ahmed, but you're not.
No, but I say the judge would need to reconsider whether Mr Ahmed's signature had been forged. And if he concluded that actually in all likelihood it was forged and Mr Ahmed is right that he's never agreed, he's never signed anything, that has to factor into his decision on whether Mr Rahman has signed the stock transfer forms and agreed to transfer some of his shares. As I made a point earlier in my submissions, which I say the judge actually recognised, you can't strip them out entirely. They do depend to some extent on each other. So in his judgment, the judge commented on uncertainty in respect of Mr Ahmed from the expert's report. So if one goes beyond that, and imagine the judge had said, well, I'm not uncertain about Mr Ahmed, actually I accept that his signature has been forged. On the judge's own analysis, he would have to factor that into his conclusions and analysis of whether Mr Rahman signed or whether his signature was forged.
But he didn't do that, that's part of the point.
Yes, so I say his analysis of the signature of Mr Rahman cannot stand because his analysis of the signature of Mr Ahmed cannot stand, and one cannot strip them apart and say, well, certain findings on these stock transfer forms cannot be sustained, but we can simply hide those off and say, well, as long as he made some different findings on the others, they can stand. I say they are interlinked, and given the case is all about forged signatures, if the judge makes an incorrect assessment of one of the two petitioners' signature and its status, it infects his analysis of the other petitioner's signature and the status of that as to whether it's forged or genuine.
Okay.
So that's my submission. He, just briefly, because I don't want to take up too much time on this, but he does say in his judgment at paragraph 77 that he finds it likely over the years that Mr Ahmed must have forgotten about agreeing to transfer all of his shares and signing the stock transfer forms. And just briefly, I'd say that was not a proper basis for rejecting Mr Ahmed's evidence to say that he must have forgotten. just briefly, I say first, the judge suggested that Mr Ahmed had had no further engagement and therefore may have forgotten about this. And in my submission, the judge has failed to identify and address evidence of Mr Ahmed in all evidence, where he described conversations he had had with Mr Rahman about the company after he had supposedly given up his shares. Perhaps I can give the references. I think I may have quoted in my skeleton, actually. I'll just double check. Yes, actually, paragraph 37.4 of my skeleton, I've inserted those references. So, not to dwell on it now, but I say the judge failed to take account of the fact that
Sorry, can you give me the reference again?
Sorry, it's 37.4 of my skeleton.
37. Thank you.
You'll find that on page 30 of the core bundle.
Thank you.
So Mr Ahmed's evidence was that he had had some engagement with Mr Rahman about the business, which the judge doesn't appear to have taken into account. His suggestion that there was no further engagement suggests he ignored that evidence. And secondly, it wasn't a point raised with Mr Ahmed that he might have forgotten that he agreed to give up his entire shareholding and that he he either signed the stock transfer form or he authorised Mr Rahman to sign it on his behalf. So the point of he may have forgotten was not raised with him as a reason for disbelieving his evidence, and he wasn't given the opportunity to comment on that. And perhaps if it had been suggested to him he'd forgotten, he might have had more to say about the possibility of him forgetting and why he would say he didn't forget. So in my submission, the judge's suggestion that Mr Ahmed's stock transfer forms were properly executed, whether by him or on his behalf, that cannot stand. I say it falls squarely within TUI and Griffiths, a failure to deal with evidence in cross-examination, and it also comes up against Al-Madini going beyond pleaded issues. As for Mr Rahman's signature, a point I've already made a couple of times, I say that cannot stand if the judge's decision on Mr Ahmed cannot stand. If he was wrong to say what he said about Mr Ahmed, he needed to reconsider that in light of the fact that those two options were not available to him. He needed to consider what the true position was for Mr Ahmed in light of the pleadings and the evidence before him. Only once he'd ascertained that could he then decide whether Mr Rahman actually had signed his stock transfer form. And also, I do say there is, I would submit some confused reasoning in relation to Mr Rahman's signature. And I made that submission based on 2 paragraphs in the judgment, if I could just briefly take you to those. If we go to page 55 of the core bundle, so on page 55 at paragraph 22, discussing at this stage Mr Rahman and Mr Rahman's denial of signing some resolutions on the 1st of November 2014. So these resolutions stated on their face that Mr Rahman was now a 5% shareholder and Mr Munim was 95%. Mr Rahman said, "I never signed these resolutions." And the judge says at paragraph 22, it may be he's simply forgotten signing the resolutions, but his denial in cross-examination in respect to these resolutions was emphatic. His evidence about signing later resolutions dated after a time when he says he signed some blank papers was less emphatic, and I wish to return to this issue. It is likely that his emphatic denial in respect to the 2014 resolutions was because he does not now want to acknowledge that he signed above the reference to 5% shareholding, lest it should be seen as weakening his case that he did not sign the forms. The reference to the forms there must be a reference to the stock transfer forms. And then the point I make is the next sentence. It is possible that he did not sign the forms, but did not take sufficient notice at the time of signing the resolutions of the reference to the 5% shareholding under his name. So at this stage in the judgment, the judge is saying it's possible he didn't sign the stock transfer forms. He did sign the resolutions on the 1st of November, which said he was a 5% shareholder, It's possible he didn't notice that reference at the time, so that didn't bring up any red flags for him. But having said that it's possible he didn't sign the stock transfer forms and that he didn't take sufficient notice of the contents of the resolutions, if we go to paragraph 75 on page 65, the judge says, in my judgment, it's likely that Mr Rahman did sign the stock transfer forms in the circumstances set out above. He was reminded of his new share allocation whenever he signed one of the resolutions referred to above. Again, he's referring back to the 1st November 2014 because those were the resolutions that set out his alleged share allocation. So, on the one hand, he's saying, well, it's possible he didn't sign the forms.
I think whenever he signed suggests he's also referring to later resolutions, isn't it? In the second sentence.
It may do, but I think I'm correct in saying that the only resolutions that actually showed the alleged 5% were the November 2014, the 3 resolutions on that date.
Okay. I'm not sure we have a complete pack of them.
Well, we have the ones that are in this bundle that either party has sought to put before the court. I have reviewed those, and I think I'm right in saying that only the 1st November 14 ones contained that reference to 5%. I'll be corrected if I'm wrong by Mr Wynne Smith and as to whether there were other resolutions that I haven't seen. But as I understand it, that was what the reference was. It was to the November 14. So on the one hand, he says, well, it's possible he didn't sign the forms and he didn't notice the reference to 5% of the resolutions. And then he says later he did sign the forms and he was reminded about his shareholding because of every resolution he signed. In my submission, this shows what could perhaps fairly be described as some confused thinking on the part of the judge as to the possibility of things happening, but then finding the opposite. I accept it's not entirely inconsistent to go down that route, and perhaps if it was an extempore judgment, one can see a judge musing on a certain topic and then concluding the opposite later. But when it's a written judgment released after the event, it does seem to suggest two contradictory approaches to the judge to when he's dealing with the resolutions. He comes up with one assessment that he may not have realised that he had 5% above his name, but then when he deals with the forms he says, well, actually he was reminded of 5% because he signed the resolutions. So I say that is a further reason why the judge's conclusion that Mr Rahman's signatures were signed by him on stock transfer forms should not be upheld. It's infected by the incorrect reasoning on Mr Ahmed's signature, which was never factored in properly into how that affects Mr Rahman, and also some confused thinking, I say, on exactly what Mr Rahman had seen on resolutions as to his shareholding and what he had signed. Just briefly, my own friend says in his skeleton that the signature on the stock transfer forms is irrelevant. I say, I may be paraphrasing him, but essentially he says, well, look, if all the shareholders had agreed to this, it doesn't technically matter if the forms were signed properly, because if there was unanimous agreement amongst them that the shares would be transferred, then the court can infer that there was an agreement by conduct and the geomatic principle would assist his clients. And I say, I think I've probably made this submission earlier, but one can't reach that conclusion on the basis of this judgment because the judge doesn't go into that analysis of was there conduct on the part of all of the shareholders to show unanimous consent to the change of the Articles of Association. But also, another problem with the analysis is that this is all based on the fact that the judge finds there's an agreement and finds all the forms are signed correctly. If the judge instead had said, well, actually, I can't be satisfied these forms were signed by on behalf of Mr Ahmed, he says that the signature was forged. At that stage, it's a possibility the judge may say, okay, well, I conclude his signatures were forged. He then has to factor that into not only the consideration of whether Mr Rahman's signature is forged or authentic, but also whether there was actually an underlying agreement in the first place. Because if Mr Ahmed's signature was forged, the question arises why? If there was an underlying agreement, why would somebody forge a signature? It's just unnecessary. So there's none of that analysis. So if I'm right that Mr Ahmed's, the judge's conclusion on that cannot stand, it infects everything I say and everything has to fall apart. And one cannot simply pick and choose which findings can be maintained and which have to be stripped out. So those are my submissions on ground one. ground 2 makes a challenge to specific resolutions that it said that Mr Rahman signed. Given timing, I'll try to deal with this quickly.
Yes, I'm conscious of the time.
Perhaps I'll just focus briefly on the second of the two the sets of resolutions. So the ground 2B challenges the finding that he signed a special resolution dated the 22nd of January 2016. The resolution can be seen at page 47 to 48 of the supplementary bundle. It's one of the resolutions that the expert was asked to comment on as to whether that may have been Mr Rahman's signature to the bottom right of that resolution. The evidence of Mr Rahman, if we go to page 146 of the supplementary bundle, paragraph 69, deals with this specific resolution. So page 146, paragraph 69, Mr Rahman says, I will draw attention to a shareholders' resolution which was attached to the defence of the unfair prejudice claim reportedly made on 22nd of January 2016. He attaches the resolution. My signature appears on the resolution dated 22nd of January 2016. I did not attend such meetings and never signed such a resolution as I was in Bangladesh from 22nd of December 2015 until 22nd of February 2016. He attaches a copy of his passport, and I won't take you to it, but there is in the supplementary bundle, pages 21 to 23, a copy of his passport and the stamps supporting his position that he'd been in Bangladesh at the time. So that's his clear evidence saying, didn't attend the meeting, didn't sign the resolution, I was in Bangladesh. And none of this was challenged in cross-examination. There was no suggestion in cross-examination that he attended a meeting on the 22nd of January 2016, despite the resolution suggesting it was made at a meeting. There was no suggestion to him in cross-examination that he signed the resolution. There was nothing said to him about him saying he was in Bangladesh at the time. So I say the judge was not entitled to find that he had signed it. And I should just take you to the judgment to show you how the judge dealt with this resolution. We go to the core bundle at page 59. Paragraph 42. And the judge says, on the 22nd of January 2016, a special resolution of shareholders was signed by or on behalf of them all, resolving that the chef should become a public limited company and adopting new articles accordingly. The expert comes to the same conclusion in relation to the signature of Mr Rahman on that document as with the other above disputed signatures. On the date of the document, Mr Rahman was in Bangladesh. However, in my judgment, it is likely that he signed this document too at some point, as it gives effect to the intention that the chef would become a public limited company, something that Mr Rahman accepts was the intention for months beforehand. In my submission, it's unfair to Mr Rahman to conclude that he signed this document. If it's not put to him in cross-examination, his evidence clearly is he didn't sign it, he wasn't at the meeting, he was abroad. It's unfair to find he signs it, absent cross-examination, putting this to him, putting the document to him, putting to him, you signed this, didn't you? Secondly, I say the judge fails to properly address Mr Rahman's trip to Bangladesh. He says at the date of the document Mr Rahman was in Bangladesh. However, it's likely he signed it at some point. It wasn't just at the date of the document. The passport shows he was in Bangladesh for approximately 1 month before that alleged meeting to 1 month after the alleged meeting, 22nd of December to 22nd of February. So the question is, when exactly was this document allegedly signed? It's not simply a question of 1 day, it's a broad period where he's abroad. Mr Munim's case and evidence was that it was signed at a meeting on the 22nd of January 2016. Well, that's obviously not the case. and the judge didn't identify a way to make this work. He's made a finding when there's no challenge to Mr Rahman's clear evidence he didn't sign it, and he's failed to identify exactly when and in what circumstances he may have signed it, if that's the decision the judge wants to reach. It's not fair to Mr Rahman to conclude that he signed it at some undefined point, given his unchallenged evidence as to his trip abroad, not being there and not signing it. Now, my learned friend will say, as he does in his skeleton, this resolution in isolation is unimportant. I say that misses the point. One cannot consider this in isolation. This resolution is one of a number of documents purportedly signed by Mr Rahman, which he disputes he signed, which the handwriting expert analyses to decide whether it's likely he signed. Now, if the judge concludes, actually, Mr Rahman obviously didn't sign this one, because he wasn't there and his evidence he didn't was not challenged, he has to factor that into his conclusion as to the other documents that Mr Rahman says I didn't sign. Why is, one can ask rhetorically, why is Mr Munim saying that Mr Rahman signed it on this date when he obviously didn't, and it's not put to him that he did? Mr Munim didn't say, oh, well, actually, I've remembered, yeah, on this case, Mr Rahman was abroad, so yes, we emailed him and he posted it, or he emailed it. It's not a situation where some explanation was forthcoming. It's simply a dispute of fact. Mr Munim says he signed it, and there's the date on it. Mr Rahman says, I didn't, and it's not challenged his evidence. So the judge was not entitled to make this finding, I say. It's unfair to Mr Rahman. That finding has to be removed. And if that document was not signed by him, it calls into question all the other documents that it said he signed, and he denies signing. So the other part of Ground 2 challenges the 3 resolutions dated the 1st November 2014. I have, due to time, I don't propose to try and go into more detail about that beyond what's in my skeleton. So I will move on. Ground 3 challenges the judge's assessment of the credibility of Mr Munim. Challenges of assessment of credibility, I accept, are hard to do when a judge has dealt with oral evidence at trial. I would just like to briefly try to support the first of those 2 points made in Ground 3, beyond what I've said in my skeleton. So the first point made in Ground 3 is that Mr Munim had made inconsistent statements as to Mr Rahman's employment status. And this point arises by virtue of the pleadings in a defamation claim that Mr Munim had brought against Mr Rahman. That wasn't, the trial of that did not take place in the court below, but the judge was referred to the defamation pleadings to support a point made by Mr Rahman. So if we go to the supplementary bundle, at page 147 is the start of Mr Munim's amended particulars of claim in the defamation claim. At 148, paragraph...
I don't think that works.
No, I think that may be a bad reference.
Oh, sorry, it's the core bundle, I apologise.
That would explain it.
Yeah, thank you to my own friend for pointing that out. Yes, so core bundle starts at page 147, the amended particulars, and 148 is where I wish to refer the court. So paragraph 3 on 148, the original pleading is crossed out and the new pleading is underlined. So the original pleading was that the defendant, i.e. Mr Rahman, is a graphic designer by profession with general knowledge of information technology, IT. And the original pleading was the defendant has from time to time provided IT and digital sports services to Chefonline, Le Chef plc and Archer Awards Limited as a consultant through his trading style iMedia London. The original pleading was that from time to time he'd been an independent contractor, and then the pleading was changed to Mr Rahman was at all material times employed by Le Chef Limited, Le Chef plc under a contract of employment dated 28th of October 2015 between him and Le Chef Limited. And Mr Rahman's position at the trial can perhaps be seen from his witness statement. If we go to page 143, of the supplementary bundle.
Sorry, looking at the judgment. Take me where are we going?
Supplementary bundle.
Yep.
Got it right this time, I think. Page 143.
Thank you.
So paragraph 60, at the bottom of 143, we're within Mr Rahman's trial witness statement. And he refers to Mr Munim as the claimant. I noticed that the claimant in his defamation claim first said that I was a self-employed consultant providing services from time to time to Chefonline, Le Shelf PLC and Archer Awards Limited from iMedia London. He refers to the relevant paragraph number of the particular claim. Over the page, but later on, sometime after receiving my pre-action letter for copyright infringement on 19th of July 2018 from my previous solicitors, Briffa, in order to defeat my copyright claim, the claimant amended his particular claim to say that I was an employee. What he initially pleaded was the truth, that I was a self-employed consultant providing services from time to time to Chefonline, Le Chef, etc. So that's Mr Rahman's position, is that he believes the change in the statement of case is to try and defeat his copyright claim. That's the reason why he initially, Mr Munim says he's a self-employed consultant, then he says he's employed. When Mr Munim was cross-examined about this, if we go to page 341 of the supplementary bundle, at just above B, towards the top of 341, Mr Munim is answering a question, and he's saying, yes, if I may just go back on my previous places, yes, I just want to add, if I might, at no time have any doubt that Mr Rahman was self-employed because of the way our relation was. And then 3 lines further down, everything is coming from me. I've never had any doubt that he was actually self-employed as he is claiming. There was never in my mind at all. Further down, just above G, the answer, well, in my mind, it's always been, I've never treated him like a self-employed contractor. So Mr Munim's evidence seems to be consistent, that he never had any doubt that this man is his employee. He never thought he was self-employed. And if that
there must have been some confusion. I mean, the whole thing's a complete muddle about the employed and self-employed. And I'm just looking at paragraph 78 of the judge's judgment, where it had Ms Begum's evidence. He was an administrative officer and a PA during that 2016.
Yes.
And she said, as far as she was aware, he was engaged as a self-employed consultant during her time, and she wasn't aware of the employment contract.
Yes, so supporting Mr Rahman's position. The point is about, I say about Mr...
But you're asking us to draw in, to allow your ground 3 on the basis of an amendment to the pleading, when the whole thing feels massively confusing to me.
Well, there was evidence going both ways, but
exactly.
my focus is on Mr Munim and his credibility as a witness, because it's apparent from the judgment there are a number of instances where the judge says, I prefer the evidence of Mr Munim over Mr Rahman and Mr Ahmed. So he obviously formed a rather favourable impression of Mr Munim's credibility.
But you're saying his credibility is undermined by this one amendment in particulars, when we can see from the evidence we've got that you've carefully drawn our attention to, and the judge's judgment, that it feels like it was a kind of bit of a moving feast, really.
Well, simply because other witnesses may go to one side or the other, it doesn't affect, I say, Mr Munim's own position in his head. He is the litigant. He says he never had any doubt that Mr Rahman was self-employed. He never had a doubt that he wasn't his employee. He never thought he was self-employed. He produces an employment contract. Mr Rahman says, well, this is your way of getting out of my copyright claim. You initially try to defend it, saying I'm employed, but you need to pull an employment contract out of the bag. So you do, and it's forged. That's what Mr. Rahman is saying. I didn't sign this employment contract. You've made it up. Now, I say it's important for the judge to look at what is Mr. Munim's explanation for his change of case. Why does he say initially his position was he was from time to time a consultant, and then he says he had an employment contract? If Mr. Munim's all evidence is, I never had a doubt he was always an employee, why would he plead that he was self-employed? The only reason it seems that was given is what Mr. Munim said in his evidence, was that Mr. Rahman had asked to continue invoicing. Despite the fact he had an employment contract, he would do invoices as if he was a self-employed contractor. And in my submission, that is no explanation to the change of case. If Mr. Munim says, I had no doubt he was my employee, he signed an employment contract, he was my employee, he asked to invoice, and I allowed it for convenience purposes, but he's not saying I thought he was self-employed, he's still saying I had no doubt he was my employee. Why does he then plead a case initially that this man is a consultant rather than an employee? His only explanation for the change is I allowed him to invoice. And my point is that is not an explanation if he always knew that he was an employee, even though he, for practical reasons, allowed him to invoice. And in my submission, the point I'm making is that the judge doesn't really engage with the point that there's no real explanation for the change of pleadings. There's two paragraphs in the judgment, I say, where the judge touches on this. Paragraph 26, which you'll find on core bundle, page 56. So paragraph 26, Mr. Munim accepts that this is how Mr. Rahman was paid, i.e. invoicing, but maintains from the outset he was employed by Le Chef and took instructions from him. He was referred in cross-examination to his pleadings where he said that Mr. Rahman initially provided services as a consultant. He replied that the invoicing was done for Mr. Rahman's convenience and he wanted financial help, and that despite frustration, he, Mr. Munim, allowed that, something he now regrets. So the judge notes the response from Mr. Munim that, I allowed him to invoice for convenience. But the judge doesn't engage with the fact that's not an answer to this point. It doesn't show why he pleaded he was a consultant when he says, I knew all along he wasn't a consultant. The judge deals with it again at paragraph 36 on page 58. Initially, it was pleaded by Mr. Munim that Mr. Rahman provided support services to Le Chef as a consultant, and a contract was only mentioned by amendment. On Mr. Rahman's behalf, it was pointed out that this position changed when it was discovered that the issue of employment might amount to a defence of intellectual property claims. There was no mention at this stage by Mr. Munim's solicitors of an employment contract, and it was only when it was pointed out by their opponents there was no evidence of employment that one emerged. Put to him that he then fabricated the employment contract by applying the same date, which he knew Mr. Rahman had signed papers, namely 28th of October 2015. This he denied, and it was pointed out on his behalf that if the shareholders' agreement had been signed by Mr. Rahman in Mr. Mia's office, then similar stamps would have appeared on it as appeared on the tenancy at will deed. So, again, the judge is alive to the point that there's a challenge to Mr. Munim on this issue of this alleged employment contract, but he doesn't identify the fact that there is no explanation for the change of case. If Mr. Munim always believed he was an employee, saying I let him invoice for convenience does not explain why he initially advanced a case that this man was a consultant. So I say that is a justified criticism of the judge's assessment of Mr. Munim's credibility. He failed to identify there was no explanation by Mr. Munim for his change of case. I don't propose to deal with the other aspects of ground 3 beyond my skeleton. Then ground 4, perhaps I can just deal with this briefly. The submission is that the judge failed to understand or consider the relevance of a contemporaneous email in April 2017. Now, there's in fact 2 emails in April 2017. Before I take you to those, I should perhaps just highlight some issues of the chronology. So everybody agrees that on the 21st of October 2014, when Le Chef was incorporated, Mr. Rahman had 25 shares out of 100, Mr. Ahmed had 10, and Mr. Munim had 65. On the 13th of November 14, Companies House filings were made at Mr. Munim's instigation altering those shareholdings so that Mr Ahmed had none, Mr Rahman had 5%, and Mr Munim had 95%. In October 2015, there was then a subdivision of the £101 shares into 10,000 1p shares, and there was an allotment of 9,900,000 shares. So in 2015, we go from 100 shares to 10 million shares. And at that stage, Mr Rahman ends up with 2.5%. He ends up with 250,000 shares. So from Mr Rahman's perspective, on what Mr Munim says is the correct position, he starts off with 25 shares. At one stage, he goes down to 5, then he goes down to 2.5 later. And I say that's an important thing to bear in mind when construing the emails that Mr Rahman wrote in April 2017. So if I could just take you to the two emails. If we go to the supplementary bundle, page 49. The first email is from Mr Rahman, dated 21st of April 17, to one of the recipients is Salik Bai, that is Mr Munim. And he says, Dear Salik Bai and Russell Bai, refers to Le Chef PLC. Firstly, I would like to clear that I am 100% loyal to you and Chefonline, but I have serious concern as to my standing within the company in terms of. He lists 4 items, the third of which is shareholding. If we go down to the bottom half of the page, just below the hole punch, he says, however, I want to raise some issues which needs to be solved. Number 2, I was put in position and urgency where I had to sign off new structure by the company's legal advisor, where I ended up with mere 2.5% instead of the original 25%. One thing to note about this is that there's no intermediate position in what he's disputing here. It doesn't talk about the alleged 5% in between. He's talking about ending up with 2.5% on the new structure. That's a transfer from limited to PLC at the same time as there was an allotment of shares. So he goes straight from 25 to 2.5. The next email is 2 days later, which starts on page 52. So again, from Mr Rahman, 23rd of April 2017, to Salik Bai and Russell Bai. He deals with shares at 0.5, so at the bottom of page 52, 5 shares, over the page. I had and continue to have good faith in Salik Bai and see him as elder brother. Salik Bai have expended the business and put in funds from his own resource, which I knew he would take it back, his loans, when the company start generating sufficient cash flow. As he was spending money from his resources and shareholding money, which I also assisted getting funds from my own network, I was not aware that my share of 25% will be diluted. I would request that instead of the 25%, I would accept total shareholding of 12.5% of the planned share issue of 12 million at par value. Now, he's talking there about his 25% being diluted. He's not, again, talking about the alleged transfer of 20% of his 20 of his shares to Mr Munim. He's talking about dilution when his shares are diluted by the allotment of a huge number of shares. So again, there's a step missing in what he's challenging here. Where is the step where he went from 25 to 5? And that supports Mr Rahman's position that he wasn't aware that he'd actually allegedly gone down to 5 before the restructure where all these extra shares are issued. So it's highly supportive, I say, of his position that I didn't know that I'd gone to 5 because I didn't sign the transfer forms, and this is all Mr Munim taking my shares unlawfully. He does not acknowledge in either of these 2 emails that there was any transfer from 25 to 5 shares. There's no email response to either of these emails challenging his assertion as to not knowing his shares would be diluted. And then how does the judge address this? Well, there's, I believe, 2 paragraphs dealing with this. So if we go to this core bundle, page 65, paragraph 73, the judge said a further indication that Mr Rahman had not agreed to this transfer, i.e. the 25 to 5%, was his assertion in 2017 that his 25% had been diluted on the restructuring. On the other hand, I found that he signed resolutions in the intervening years in which his shareholdings referred to 5%.
I think that's relevant to the point I made earlier about the intervening shareholder resolutions that we don't have.
Well, I'll be correct if I'm wrong, but
yeah.
my understanding is, from what I've seen, that it was only the ones in November 14 that dealt with the 5%.
I've had instructions now that my instructing solicitor has identified 9 resolutions in total, 3 that we've got here, plus another 6, and that includes the resolutions in the following year, all of which refer to 5% and 95%.
Perhaps we could be provided with copies.
Indeed, we shall.
Thank you, that would be most helpful.
Okay, well,
I just think it'd be useful if we had a complete set and then there's no room for
I understand.
misunderstanding.
Yes. For my part, I would wish to consider whether any of these other ones were put to Mr Rahman in cross-examination specifically as ones that he signed and therefore were...
Well, you'll know that because you've read the transcript already, so you'll know which ones were put.
Yes. I'd not identified any being put for a purpose of pointing out the 5% other than these, but I'd perhaps want to double check that, depending on whatever is forthcoming now that I'm not currently aware of.
Well, I think the point I'm making is my reading of the judgment, at least, is that the judge makes findings about that, and he specifically talks at various stages about the resolutions.
Yes. I think I'm fair in saying there's a lack of clarity in the judgment as to what the 5% resolutions the judge is referring to.
Yeah.
He does make the point that Mr Rahman was categoric in saying he denied signing the 1st November 2014, the 3 ones on that date, which had 5%.
Yes.
The judge makes the point that he may have been doing this to try and avoid the conclusion that he would have seen the 5%. The judge doesn't clearly say, well, there were other ones that he hasn't denied which say the 5%. Now, one might maybe infer that from these references, but it's not clear, I say, that he's taking into account other ones that he says, well, there's another one, 5%, which Mr Rahman didn't specifically deny. That's not clear from the judgment at all. So if that was the point the judge was making, that one can ignore the ones he categorically denied because there is one or more that he admits he signed or that was put to him and I find he signed, that might make things different. But in my submission, there's no clear finding in this judgment that there was another resolution beyond those ones which Mr Rahman signed and therefore would have seen the 5%. But going back to my point about the April 17 email, first sentence of paragraph 73 is clear. The judge has got the point that the fact that he asserts his 25% has been diluted on restructuring is an indication, amongst others, that Mr Rahman didn't actually agree to the original transfer of 20 shares away to Mr Munim. Following that, he deals with this again in paragraph 75. So if we look at 75, 4 lines from the bottom, there's a line starting taken advice. And after that, the judge says, whether his reference to 25% was part of the confusion displayed in those emails as to the true position which then obtained, or a more concerted attempt to achieve a better result, I'm satisfied in the balanced probabilities that he signed the share transfer forms. So having recognised this 25% dilution reference in the April 17 emails is supportive of Mr Rahman's position, the judge has 2 ways of disposing of that, saying, well, actually, that doesn't actually preclude him from his finding that he signed the stock transfer forms. One is that it's confusion displayed in those emails of the true position, and 2 is it was a more concerted attempt to achieve a better result. I say neither of these are appropriate as a way for trying to reject the persuasive effect of these contemporaneous documents to Mr Rahman's case. Firstly, confusion displayed in those emails as to the true position. Well, if Mr Rahman is right that he did not agree to transfer 20 of his shares away. He thought he had 25, and then on the restructuring, he went from 25 to 2.5. That's not the confusion as it is as to the correct state of affairs is because Mr. Rahman didn't know that there'd been an unlawful transfer of 20 of his shares. So if he's right, his email may well look confusing to the judge who says, well, actually, I find you did sign these transfer forms, so it all sounds very confusing, your email. Actually, that's the wrong analysis. The analysis is, his email is entirely consistent with what he says, is that I didn't even know, so it's not confusing, other than that he's confused because he doesn't know what's going on.
Did he put a case that I thought that the 2.5% was purely the product of dilution? In other words, that whatever restructuring was done took him from 25 to 2.5? Because I think that's the way you're putting it now.
Yes, I think that's the way that he understood it in those emails, and then later it suggested to him that he actually had transferred 20 away before that, and then his case at trial is, well, I didn't do that, that never happened. So as I understand it...
He's effectively saying that in the email at page 53, I think.
Yes, I was not aware that my share...
As my lady said, I was not aware that my share of 25% will be diluted.
Yeah, so his position back in 2017, I say, just looking at the wording he uses as a good indicator of actually what was going on at the time in his mind, he showed no awareness of this alleged transfer of 20 shares away from him at that stage. So yes, it is simply his position there, as he understands it, is he's going for 25 to 2.5, and he's unhappy about that. He's then more unhappy when he finds out that actually he'd already gone down beforehand, he says, in a way that he hadn't agreed to.
We know when we're looking at 53, given that that was just 2 days later, that he was thinking in terms of at the sign-off of the new structure, because one of his complaints at paragraph 2 of page 49 is, I was put in a position of urgency, it had to be signed off, where I ended up with a mere 2.5 instead of the original 25%.
Yeah.
So I, for my part, speaking only for myself, when I read these, I was thinking that what he was saying was that he hadn't known until now that it had reduced from 25% to 2%, and that was all because there'd been such a rush when he had to sign it.
Yes. Yes. So yes, I agree that that's what I say this is demonstrating, and that obviously from Mr Munim it's not accepted that that's what happened, because their case is that he actually knew he transferred 20 away before that, and the judge then has to deal with these contemporaneous documents. And in my submission, the judge has failed to adequately deal with them, because the first issue, confusion, well, it's not confusion on Mr Rahman's case, it's just setting out what he understands to be the case if he's right that he never agreed to transfer 20 shares away. The second option the judge gives is that it might be a concerted attempt to achieve a better result by Mr Rahman. Now, the origin of this suggestion of a concerted attempt to achieve a better result, I submit, is likely to have come from some cross-examination of my learned friend on the 21st of April email. And this is in the supplementary bundle at page 252. So, page 90 of the transcript, if we go to E, question just below E, just above F. I think that's what you said earlier. If you could please look at G92. So this is the 21st of April 17 email. It's the first page of that in the trial bundle. This is an email. You looked at it before for a different point. This is 21st of April 2017. Yeah. And look at the bottom of the page. You here are making points about the conversion of the company, and at number 2 you talk about the fact that your shares are at about 2.5%. Yeah. You didn't find out in May later, sorry. You didn't find out from Syed Umar Ali in May that following on from this, you knew beforehand because you were writing about it yourself in April 2017. Well, I may have got the dates wrong. So the point there being made in cross-examination is just that he's got the dates wrong as to whether he found out on his case about the reduction of his shares in April or May.
Now, Mr Jacobs, I'm going to have to hurry you up.
Okay.
In fairness to
yes,
the respondent.
I'll finish quickly now. Just so
we have got the benefit of the skeleton argument, which we've read.
yes.
If you just want to highlight any further points on ground for.
Yes, 91E to G. This is, I say, where it looks like he gets the concerted attempt to achieve a better result. So, page 253 of the documentary bundle at E. Question, now over the page at G93, bottom of the page, you say my shareholding needs to be increased by a further minimum 10% on top of the existing 2.5% at par value, yes? That's because you write that because you knew that your shareholding position at the time, no. You knew it, no. It's why you're asking for more. And then the answer from Mr Rahman is why? If I knew then, why would I ask for more? Basically, I know I've been done over. Now I'm trying to negotiate whatever I could without, obviously, he's taken everything. So I'm just trying to be nice and trying to be polite and trying to get whatever I could from out of this. It's nothing more than that. This appears, I say, to be the origin of the judge's reference to the 25% could be an attempt to achieve a better result. But I say, how would that even work? Imagine Mr Munim's case is correct. In Mr Munim's case, Mr Rahman has signed a stock transfer form giving 20 of his shares to Mr Munim, leaving him with 5. Knowing that he knows that, knowing that Mr Munim knows that, to then, in 2017, email him saying, I wasn't aware that my 25% would go to 2.5. How does ignoring what they both know that he'd signed a stock transfer form and already given away 20 get him a better result? It doesn't make any sense. If Mr Munim's right, it doesn't make sense. It only makes sense if Mr Rahman's right, that he'd never agreed to give away 20, and that's why he's just not referring to that when he's saying what his gripe is. He's got no reference to that because it didn't happen. And I simply say the judge has failed to identify the relevance of these emails, and he's failed to deal with them when he disposes of them. Essentially, he says, yeah, I can put those to one side, despite their apparent assistance for Mr Rahman's case, because of 2 reasons. Neither reason adds up, so I say he could not put those to one side, and he's failed to adequately deal with the assistance of those emails to Mr Rahman's case.
Thank you.
So I think that's the end of my submissions. And I'd just say, just as one closing point perhaps, if the court concludes that the findings that were made in relation to signatures where points weren't challenged in cross-examination can stand, I say it would set a remarkable precedent that these are key issues in the case as to whether somebody signed a document or not. They say they haven't in their witness statement. It's not expressly challenged. If this court says, well, generally in all the circumstances, everybody knew this was an issue, so it was not unfair to omit that in cross-examination, it effectively, I say, wipes out the rule pretty much in TUI and Griffiths that you're supposed to challenge evidence if you want to invite the judge to find something contrary. And it will simply be a license for people in future to just avoid cross-examining on difficult issues where they know they're not going to get a decent answer for their client. They're simply going to give the other side a chance to explain, which they don't want for their client. The reason we do it in cross-examination is because we have to, because it's a rule of fairness. We have to challenge evidence if we want to obtain a finding contrary to that. So those are my submissions.
Thank you very much indeed. Sorry to have rushed you.
No, yeah, it's fine.
Yes.
My ladies, my lord, please you. Turning to the law first, I'm going to be very quick on just a few points to identify. And in the authorities bundle at page 18, tab 1, you've already been taken to this, it's paragraph 42, and of course it's accepted that the general position is that the party is required to challenge in cross-examination the evidence of any witness of the opposing party, if he wishes to submit to the court that the evidence should not be accepted. Straightforward. At 23, within the same judgment, paragraph 56.
Sorry, your first reference was to paragraph.
Just to the quotation that's set out within 42, and it's the general position, it's between G and H.
Thank you.
At page 23, paragraph 56, there is a reference to Cheng and and going down to the very bottom of that paragraph, it's stated that both grounds could reasonably be expected to have been put in cross-examination, and it was possible that Mr Munim would have given believable evidence which weakened or undermined those grounds. And I pause on that because what this shows is that there has to be a causative link between the thing which is asserted not to have been done or not to have been put and the unfairness or prejudice that may ensue as a result of that. In Ali and Dink, this is within that case, within the authorities bundle at page 37, paragraph 25, down at the bottom of the page. Lord Justice Birss's comments to the statements of principle, the additions that are added, which we've already looked at briefly. But the third line down, I draw out the common sort of prejudice which is to be avoided is that a new point has arisen in such a way that the losing party was not given a proper chance to pull evidence or ask questions which could have addressed it. And so that's again going to the prejudice point, which I highlight. Over the page 38, within paragraph 30, point that was relevant in that case is that matters weren't necessarily implicit within a case. That's the very bottom line. And so even though there weren't explicit aspects of pleadings, certain matters that were then relied upon could properly be said to be implicit. And then finally within this case, paragraph 34, which is on page 39, we can see there that it's written, in the closings at trial, the case was argued out fully by counsel before the judge. In no sense could it be said that the appellants were ambushed or precluded from advancing submissions or evidence which they might otherwise have done. The appellants have not identified any step that they might have taken but were deprived of the opportunity to take because of the way the case was decided. No evidence has been identified which the appellants might have called but did not, nor any questions which might have been asked in cross-examination, nor any authority which might have been cited. No prejudice to the appellants of any sort has been identified. And I say that all of those considerations will apply here. Turning to Chen and Ng within tab 5, the extract which I seek to take you to is at page 101, paragraph 52. Again, it's been referred to briefly already, drawing the distinction between the perfect world and the imperfect world in which we live. And we can see at the bottom of that, once it is accepted that not every point may be put, it is inevitable that there will be cases where a point which strikes the judge as a significant reason for disbelieving some evidence when he comes to give judgment has not been put to the witness who gave it. And then over the page, paragraph 55, there are some comments about the test at a high level of generality, but then also there are some specific factors set out, 4 lines down, which should be taken into account. They include the importance of the relevant issue, both absolutely in the context of the case, closest to the grounds of the points which are put to the witness, the reasonableness of the grounds not having been put, including amount of time, and so on. And then at the bottom, in some cases, the plausibility of the notion that the witness might have satisfactorily answered the grounds. And then we see a quotation from Biogen, which is set out within paragraph 56. Specific findings of fact, even by the most meticulous judge, are inherently an incomplete statement of the impression which was made upon him by the primary evidence. His express findings are always surrounded by a penumbra of imprecision as to emphasis, relative weight, minor qualification and nuance, of which time and language do not permit exact expression, but which may play an important part in the judge's overall evaluation. And then right down at the bottom of this page at paragraph 60, there we can see in that case that it was not hard to conceive of answers which might have been available to Mr. Ng to answer the first round, which might have satisfied or at least mitigated the judge's concern. Now, I say that this case is very different when we're concerned about the causation of any sort of prejudice about what may not have been put or has been put, and I will develop that in due course. But those are the only points I wish to draw your attention to.
Thank you, that's most helpful.
pleaded case is essential to understand, of course, what was properly an issue. And I don't agree that this case was all about handwriting and signatures. I say it was principally about the underlying agreement, which was anterior to, fundamental to the things which then happened afterwards to put that agreement into effect. Within the amended points of claim, this is within the core bundle at page 79. Paragraph 7, it makes the point about the change of the shareholding, and the last sentence is, this is page 79, paragraph 7, and this is the amended petition. The headline point there is, they did not consent to any changes to their shareholding. So the fundamental underlying point. At page 81, paragraph 16, the defendant and the third party had not agreed to any transfer of their shares, nor was the claimant entitled to transfer them to himself. It's about not agreeing. At paragraphs 19.2 and 19.3 over the page, there are then pleadings relating to the stock transfer forms, but they follow on from the first set of aspects of pleadings, challenging whether there was an agreement in the first place. And at page 83, within paragraph 22, there is a pleading which correctly identifies Article 26.1 of the model articles, which makes the point that shares may be transferred by means of an instrument of transfer which is executed by or on behalf of the transferor. So within the Articles of Association, that was the method. It didn't need to be executed by the transferor. It could have been done on behalf of the transferor, and that would have come within the Articles. And this was identified within the petition. And then at 85, paragraphs 30 to 32 deal with the shareholders' agreement and an allegation about the shareholders' agreement not being a deed because of a signature, a witnessing point. And it's challenged there, but it is noted here that there is no part of any of the grounds of appeal that seek to challenge the judge's findings about the shareholders' agreement or the employment contract. In the amended points of defence, page 97, paragraph 21, is a clear pleading about what had been agreed between the claimant, the defendant and the third party, that the claimant would loan a sum of money to the company, and in return the defendant would transfer 20 of his 25 shares and the third party would transfer all of his 10 shares. So that comes first, what they agreed. And then at paragraph 22 is that in accordance with that agreement there is the execution of stock transfer forms. And I do say that those words are sufficiently wide to allow the formulation of Article 26.1 to be complied with, so where it says the defendant and the third party executed stock transfer forms. It would have been clearer to say and or, but I do suggest that that is by itself sufficiently wide. 27 to 29 on the next page, again refer to the transfer. At the bottom of page 98, we have paragraph 32. First, the transfer of the defendant's and the third party shares to the claimant was with their consent and properly authorised. And then at 33, there is a pleading in relation to the alternative position. If the stock transfer forms had not been properly executed and the shareholding remained as it had been initially, then the claimant could, by an order of a specific performance, compel the defendant and the third party to transfer their shares, which again is reiterating that it was the underlying agreement that was critical here. The rest of it is the machinery that then puts that into action. And then at page 101, paragraph 42, at A, there is a pleading setting out what was shown in the shareholders agreement, which had a clear representation of the original structure of the shareholding before the restructure that then followed thereafterwards, and included within that, along with all of the resolutions, was a very straightforward account of the defendant having 5% of those shares. And you'll see it's 42D, that document is signed as a deed, and there is a pleaded reliance on the doctrine of estoppel by deed.
Sorry, which page are you on?
That's page 101, paragraph 42D.
Thank you.
And then in the reply at page 107, these points are all engaged with. You can see at paragraph 9. That's about the original agreement and there being a challenge on that. At 13, an engagement with the actual stock transfer forms. And here, midway down through the paragraph, Mr Rahman cannot exclude the possibility that such documents were given to him as part of the documents he was asked to sign in October 2015. That's what he's put there.
Sorry, that's not Mr Ahmed, that's Mr Rahman, isn't it?
Sorry, Mr Rahman, yes, my mistake. And then at 15 and 16, this is the bit that critically engages with, again, whether there's authorisation. There was no such consent or authorisation on the part of the defendant and or the third party. And then at 16, a reiteration that there was no such agreement. Therefore, they couldn't be compelled to act in accordance with that agreement. So that's a clear engagement with those pleaded issues, and that's going to the question of authorisation as well as execution. And then finally, at paragraph 19 of the points of reply, the amended points of reply, page 109, is the response in respect of the estoppel by deed point. And the only thing that's said there is it isn't valid, it can't operate when it's tainted by fraud. If it isn't tainted by fraud, then my suggestion is that that entirely falls away as a point that can be relied upon. So those are the relevant pleaded elements dealing with what was in issue here, and it was not just signatures and handwriting. The skeleton arguments are in line with that. And the first reference, please, is within the same bundle at page 172. And this is the skeleton argument produced for Mr Rahman and Mr Ahmed together on the company matters. These are part of the new documents.
Thank you.
And halfway down through paragraph 2, we can see clearly the main issue in dispute is whether Mr Rahman and Mr Ahmed consented to the transfer. At page 190 is the skeleton argument on behalf of Mr Munim and the companies. This is the portion that then begins to address the company claim. On page 190 are matters dealing with the pre-incorporation discussion. On page 191, we then get to the first restructuring. And here it starts off with the agreement that the defendant there would transfer 20 of his shares to the claimant. And then at paragraph 19, in accordance with the underlying agreement, then various things happened. That's how it's put. The agreement comes first. And then at page 197, paragraphs 44 through to 49 are relevant on this issue. And in particular, it can be seen at 48 that it said that if the stock transfer forms were not signed, then pursuant to the duomatic principle, it can nevertheless be put into effect. There is an authority within the bundle that I haven't taken you to, but I hope that the reference to it in the skeleton argument is sufficient. But here it is put out within the skeleton argument, so it's a clearly flagged matter that's before the court. And again, you can see the estoppel by deed point is at paragraph 50. That's on page 198 as well. And then finally from this document, at page 222, paragraphs 143, 144, they are a reiteration of what has gone before, but are in line with those points. Then we come to the openings, and if you could please turn to the other bundle, supplemental bundle, and page 161 is the transcript that shows Miss Wonnegott's opening. And just above C, there is an account of what Mr Munim says on the other hand. And then at D, there are supplemental forms in the bundle. Mr Ahmed and Mr Rahman do not just say they didn't sign them, but also that they never consented to any transfer. And that might be an important distinction. And then at the bottom of that paragraph, so just to be clear, we say there was no agreement that they would transfer their shares to Mr Munim. So everyone understood that it was a multifaceted point here, that the agreement was something that needed to be determined and was before the court. And part of that then feeds into potentially authorisation of then the procedural mechanism that allows that agreement to be put into effect. And over the page at 162 is part of the opening that you've already been taken to from me. And at D, we can see there, and so there is an overarching issue which is addressed by the question of whether there was an agreement. And at F, a reference to the importance of the shareholders' agreement. So now turning to the grounds, and the first ground, which is found at page 15, simply that the judge's findings in relation to the stock transfer is contrary to evidence. That's the headline ground. And then at 16 is A through to F, individual bits that are taken. It's of note, in my submission, that Mr Jacobs' skeleton argument addresses this first ground, page 29, from paragraph 33, for the next 3.5 pages, nearly 4 pages, all relating to Mr Ahmed. When it comes to his client in this appeal, all he has that stands alone in respect of Mr Rahman is paragraph 48 at the bottom of page 32, and then 49 and 50. That's it. And I will, of course, return to the question of Rifat Ahmed. But if we deal principally with these, then The first aspect that is looked at is paragraph 22 of the judgment, which is said to be inconsistent with a later position. Paragraph 22 of the judgment, which is found at page 55, needs to be seen in context, because this whole first section of the judgment goes through making findings on points as they arose within the chronology of events, but had left over the question of main issues to later. And so that can be seen at page 52, paragraph 5. There are several subsidiary factual issues which I must determine. I will set out the background to the claims, and in doing so determine such subsidiary issues where convenient to do so before returning to the main issues to determine those. And then the chronology goes through effectively in the judgment. We can see at 53, first of all, draw attention to some important points. At paragraph 7, that there was cross-examination about the original business that Mr Ahmed and Mr Rahman ran together. The conclusion there is, in my judgment, it is likely then that by then this business was not as successful as they had hoped and was struggling financially. The first finding that effectively went against the two of them in respect of the context to then why there were later discussions in October 2014. And the fact of that context is made explicitly clear at the top of paragraph 8. Then at 54, in paragraph 12, there is a determination about what had been pleaded as to whether there was an open-ended investment that had been promised by Mr Munim. And the judge found against Mr Rahman and Mr Ahmed on that. In my judgment, at the end of paragraph 12, it is inherently unlikely that he, as an experienced businessman, would agree to such an open-ended investment on such limited information. And I prefer his recollection as to the initial discussions. Paragraph 14, there is then a disagreement on the evidence about what was required by way of further investment. So this is when two of the protagonists were in Bangladesh at Dhaka, and a potential backer, Mr Russell, who is the Bangladeshi industrialist, said that we need to think about this again. And this is what Amber IT relayed back. And the conclusion here, again, is that this part of Mr Munim's evidence, with some support from those concessions, rang true and I accept it. So it's another point of the background where Mr Munim's account is accepted and the appellant's account is not. Then there are various sections, paragraph 16 onwards, dealing with resolutions. And here at paragraph 17, there is the reference set out explicitly within the judgment to 95 and 5%. And at paragraph 18, the same date, which then supports the fact of the force of those resolutions, is that a tenancy will, which had been referred to in one of the resolutions, was put into effect. So it didn't look like they were simply bits of paper that were generated that didn't do anything. They did real things. And those things were determined by the judge to be sensible things for the company to do. There's no reason to doubt that those resolutions were therefore, on that basis, genuine, and it would also make sense for the relevant shareholders to sign those resolutions. Paragraph 21, that conclusion can be seen. Each of the resolutions, or three of them at that date, were in the interests of Le Chef and were put into effect at the same time. And then we get to paragraph 22, which is where some reliance is placed. Here it is set out that one possibility, that's all it is that there had been some forgetting by Mr Rahman about signing the resolutions. But then he suggests, but the denial was emphatic. The possible explanation for that emphatic denial is simply to shore up what he wanted the case to look like, and that it could have been that that was all that was there to see. And then it's floated as a possibility at this point only that he did not sign the forms. That's towards the bottom, the penultimate line of paragraph 22, but did not take sufficient notices at the time of signing it. And I suggest there's no finding here about this because this is dealing with the resolutions, not the forms, and so it's just working out what a logical possibility could be at that point, musing about what then would be sorted out with a determination in the later part of the judgment when the stock transfer forms are specifically addressed. So the potency of the argument that there is some inherent conflict between paragraph 22 of the judgment and then what follows, I say, is removed. That's what it was going to. And so turning back to the skeleton argument in support of the grounds, we have 32 and 33, the development of that point. And that's all it is. Paragraphs 48 and 49 were the skeleton arguments. And then the final point that Mr Rahman alone relies upon is the fact that there were two sets of signed stock transfer forms. And it's asserted that the judge didn't pay proper regard to that. But the judge considered the point. It's noted expressly within the judgment that there were two versions. And he said, nothing turned on it. The expert had both versions. And that can be seen within the supplemental bundle at page 56. The references there. They're both identified as documents that the expert could see. And it didn't make any difference to the determination of the expert as to how likely the signatures were, those who were said to potentially sign them. And then at the supplemental bundle at 316F, this is part of the transcript of the cross-examination of Mr Munim about this. And halfway down the page at about E, it says, now let's look at the stock transfer forms. And then at the end of E, it concludes, why are there two transfer forms? And Mr Munim's answer was quite often query, because I didn't quite pick up on the transcript. Two copies are done, one for record keeping, one to be sent away to either the accountant or to Companies House, you know. So it's quite common having two copies. So there was an explanation provided in evidence by Mr Munim, which of course the judge will have heard, and this point is considered. So that's it. Those are the only points that are raised directly in respect of Mr Rahman, and in my submission they're without foundation. Therefore, my learned friend seeks to rely upon Mr Ahmed and any complaints there, and to suggest that that imports across an infection that makes every finding improper or unsafe. And I say it's wrong on the basis of the sheer quantity of findings that go to Mr Rahman, his credibility, and the underlying understanding of why there was an agreement in the first place, which was all very well evidenced and expanded upon in cross-examination. Turning to some of the questions that were put on these issues. First of all, at page 234, within the supplemental bundle, as part of the transcript, questions being put to Mr Rahman. At D, the judge asks a question, did Mr Russell say to you that your proposal would not work? It was not enough money and there needed to be about £100,000. And then the answer is E, yet we had many discussions. And then eventually we fast forward across the page at 235 at F. It was put to you, I'm suggesting, you don't remember this bit very clearly, it seems, that everything needs to be increased in scale. A lot of different investment is needed. And I'm suggesting that it was then that you had a telephone conference with Rifat Ahmed and you explained that position, and also that as a result of it, you and Rifat Ahmed were being asked to increase your contributions to the company. He says he doesn't recall. And then there's some to and fro. If you go to 236 at F, the judge asks, you still say you cannot recall the conversation with Mr. Ahmed? Yes. And then at 237 G, where really it finally gets put back together, they're having again been to and fro on the issues. And the last bit of that I'm going to put to you is that Rifat Ahmed's response to you was, I can't put any more money in. So he was being asked to put in £10,000 and I can't be based in Dhaka, so I'm out. Have my shares transferred to Mr. Munim because he couldn't do what was being asked of him. He couldn't put in the cash and he couldn't be there. And you said to Mr. Munim, yes, that's agreed. To which his answer is no. Of course, he denied it. And so that was in respect of Mr. Rifat Ahmed. The background had been, he'd been asked to put in, he had to do one of two things on Mr. Munim's case. He either had to make a financial contribution because of the massively increased scale of what was needed to make the business work, or he had to commit, as Mr. Munim had always anticipated he would, to being based physically in Dhaka to run that particular part of the operation. And because he couldn't do either of those, he said, no, I'm out, basically. That was Mr. Munim's case. It was put to him, he denied it. And then over the page at 238, this is now addressing Mr. Rahman. And then in your case, there's a big difference. You said, I can't afford the contribution you're asking for this, £25,000, which has gone up. Then at B, you said, first of all, that you couldn't afford that, but you could raise some finance and you would be prepared, and you agreed to transfer 20 of your 25 shares and you would contribute a sum for the remaining 5%. And that's what you said about your shareholding. Do you agree with that? I did not say that. He disagrees. And so those are points about the underlying agreement, I say fairly and explicitly put, denied. And then at 241, at E, moving on to the stock transfer forms, they were introduced at that point. And then over the page at 252, at A, it said, I'm suggesting that shortly before the 1st of November meeting, you were handed unsigned stock transfer forms. He says nothing like that happened.
Sorry, 242. 242.
Yes.
Yeah.
So the stock transfer forms have been introduced as a part of the questioning. You were asked to sign and asked to have Rifat Ahmed sign, and that either at the meeting on the 1st of November or shortly afterwards, you were reminded by Mr. Munim that he would like those documents back signed. And you said in response, I'm waiting for Mr. Rifat Ahmed's documents. He said nothing like that happened. There is obviously clear questioning on this issue, which is central. And then there's a reference to the 2nd of November email, which was surprising to Mr. Munim because this appeared to be from Mr. Ahmed suggesting that he was reconsidering the position. Surprising to Mr. Munim because his evidence was he thought the deal was done. At F, we get to here the question, now when it came in, Mr. Munim was a little confused about it. You discussed that email with Mr. Munim. Do you remember that discussion? No, is the answer. I'm suggesting to you that Mr. Munim told you and you agreed this proposal couldn't work, but this is the proposal of Mr. Ahmed to work remotely. Do you remember that? No. And then finally, now, because therefore that didn't change anything, you then, 2 days later, brought to Mr. Munim the now signed stock transfer forms. That's the progression. There was a last-minute email saying, I might be interested after all. You discussed it with Mr. Munim. He said, no, that didn't work. So you then brought in the stock transfer forms. That's how it happened. And it's denied. And there is no word there that says, and you signed one of those on behalf of Mr Ahmed, for Mr Ahmed's bit. That's true. But I say that there is plenty here within this line of questioning to allow all of those issues to be ventilated and for an appropriate level of scrutiny about this part of the case to be before the court so that sensible findings about these matters could be made in line with the pleadings. And of course, the follow-up question, the additional question that could have been asked to make it explicitly clear on whether there was a signing on behalf of Mr Ahmed, of course, only goes to Mr Ahmed. Does not go to Mr Rahman himself. He, on Mr Munim's case, simply turned back up at the office and handed the stock transfer forms which had been given to him unsigned, now signed. Mr Munim hadn't seen where that had happened. He took them at face value, as is explained in his evidence. And he was cross-examined about that process as well, and that can be found back at 317. We started to look at that on 316 about there being two transfer forms, but at 317 the cross-examination moves on. At the top of the page, yeah. On that, I did not physically get the form from Mr Ahmed. I did not physically give it to him. Mr Rahman, who was the middle person who dealt with it. What Mr Rahman gave me, I believe that's what it is, but beyond this, I can't comment. He didn't check by email. He was asked, did you do that? No. It's because something that Mr Rahman said he would take care of, and I naturally left it to him. Now, there's nothing there that suggests in the cross-examination that it was concocted in any way. Nothing was put to Mr Munim that he'd made anything up or that it was a forgery. That was the extent of the questioning to him. So that's what was before the court, that he said, I gave these blank forms. They came back to me from this man, and there was no suggestion that Mr Munim had made anything up about them, and that was what the court then had on that issue. And then if I may take you please to 268, again within the transcripts. This is now Mr Ahmed. And at the bottom of 268, there is a reference to an initial investment. And then at H, there was a question about whether the whole of the work in Bangladesh needed to be started from scratch, that everything needed to be built from the bottom up. So nothing, virtually nothing, could be used from what had been done beforehand. It needed to be started afresh. That was their view, i.e. the Amber IT consultants, and that's why it was so costly. To which Mr Ahmed responds, that was their opinion maybe. Yes, and you might not have agreed with it, but that's what Mr Russell was saying, and that's why there then came the new position, which I say was relayed to you, which was if you want to be part of this, as it's now seen, you need to put in money or get over to Dhaka to run the place. He says he never had that conversation with Mr Rahman. He denies it. And then at E, what I'm suggesting with all of this, that there was one person who was relaying this to you, and it was Mr Rahman. So there's two things. There's what happened there in Dhaka. You weren't there, and we've heard what Mr Rahman says about it. And then after that, there's whatever Mr Rahman told to you. You dispute that he said to you, you need to put in money for your shareholding now. Is that correct? That's not correct. He never told me I needed to put money in for my share. You needed to go to Dhaka and actually run the outfit. That was the alternative. You needed to be there. No, he didn't ask me that. This is about the underlying agreement. Of course, it's put, he denies it. And the question at the bottom, and my suggestion to you is that these conversations did happen, it was relayed to you, and your answer was, well then, I can't continue because I don't have the money and I can't go there, so take the shares. and that's denied. Over the page, that's false, that's not true. And then at the bottom of that page 270 is the bit that we have looked at already with my own friend, but it's the part about the stock transfer form. And I'm suggesting that shortly after this, because there was a change of heart about what might happen with your involvement, you then confirmed to Mr Rahman to go ahead with the stock transfer form, and you gave your agreement that your shares would be transferred. And that's flatly denied. And I say that that question is a fair way of putting to that witness and party that he had authorised the stock transfer form. He had authorised the machinery that puts in place the agreement. Now, he denied the agreement had been reached. It was put to him, he denied it. He denied that he gave his authority. He says that's false. But I say these were questions fairly put, and again, are appropriately aligned with the pleadings, how the case was opened and argued, and that this was not unfair to this witness and party, and the judge therefore was able to make safe conclusions and findings about these matters. Now, turning to ground 2. These, the ground is a little unclear. Perhaps we first look at that. At 16, and it simply states that the findings that Mr Rahman signed the company resolutions is contrary to evidence. Although A and B that then follow appear to be relating to 4 resolutions, I think at A, those relate to the 3 of the 1st of November 2014, and B relate to the 22nd of January 2016, but the ground, as an initially drafted, appears to relate to all of the resolutions. There were, of course, several that took place in 2015. And the judge does also deal with those at length within judgment. And it might be sensible for me to jump in at some of that point, because that has arisen part of the discussion here in court. Now, at page 55, paragraph 21 within the judgment, we looked at briefly. That was in respect of the first set of resolutions, which may be the 3 related only in A. And the judge has analysed the supporting machinery that was put in place by those resolutions, and that they were effected, and that formed part of the ground for supporting those matters. And moving on to 57, we then get at paragraph 31, the introduction of the letter of the 28th of October, which stated that it enclosed copies of the employment contract and the shareholders agreement, and there is an account of the differing, setting out the differing accounts within the judgment at 32 and 33. At the bottom of 33, it is noted that there are multiple different accounts of what is said to have been signed by Mr Rahman, and it starts with, in pre-action correspondence, his solicitors denied signing this version. Later, that he signed blank pages, and then later it was that there may have been some typing on it. And then finally, it seemed to be that he accepted some documents, but it was a different document. So the judge had in mind the changing scenario on that, And this was at the same date that there was an admission by Mr Munim that he signed some other documents which he says may have included the later series of resolutions. He never identified those resolutions because he said of all of the documents that he didn't know what they were. But he apparently begrudgingly accepted that they may have related to some of those documents. Hence the judge's treatment of them being different. There wasn't an emphatic denial about signing those particular resolutions, and of course the shareholders' agreement and the employment contract. But then there are clear findings. If we go over the page at 58 to, first of all, 35, there's the reference to there being several further resolutions of Le Chef. And it includes a registration of the allotment of new shares. That's one of the things that's identified there. But also share restructuring, the appointment of Mr Roussel as a new director, and other matters. And we'll see at the middle of paragraph 35 that he accepts that he signed. He says that he could have signed these. His answer was he could not comment. This was in contrast to his emphatic denials of signing resolutions in 2014. Then at 37, it's identified that those purported signatures were included in the disputed signatures examined by the expert, and so the same conclusions as the earlier resolutions will apply. And then at 39, the conclusions of the expert, taken together with the evidence of Mr Mir, in my judgment, make it likely that Mr Rahman did sign these documents and that Mr Mir dealt with them as he recalls. That's important because Mr Mir is a solicitor whose evidence was preferred over Mr Munim. Mr Mir gave nuanced evidence. In one respect, he did not accept part of Mr Munim's pleaded case, and that gave credence for the judge in his assessment of him. But also he noted distinctions between the tenancy at will document, which is also a deed, which was signed in Mr Mir's presence. He put his stamp on it. Whereas the other documents that were about which there was a factual dispute, and Mr Mir said that they were taken away, did not have the stamp. And that also impinged on the judge's mind about what was more likely. If those then are difficult to be set aside, and in fact they are not part of the grounds of appeal here, there is no suggestion of the shareholders' agreement or the employment contract being set aside or interfered with in any way, then there is the estoppel point, and again another reference to the shareholding that's contained within that document. Whilst we're on page 59, if I could ask please to go to paragraph 43, and this picks up one of the other points that has been raised about the April communications. Here, in this section, there is a long narrative that deals with both the emails that have been referred to and what happened around those. It starts with 43 about the concerns raised, and then at 44, it was later that month that Mr Rahman emailed Mr Munim and Mr Roussel with concerns about his position. Now that email can only be the first one that we looked at, the 21st of April 2017. We know that because of the quoted text within that paragraph matched that email. And then we can see at 45 that it's said that that was then copied to the Director of Marketing. We know that, Mr Akhtar Rozaman, that's shown on the email. And then a couple of days after and then we're also told before the next email that there was a meeting. Then at 46, there's a reference to the 23rd of April 2017 email. It's the second that we looked at briefly beforehand. And then that all culminates in a meeting which is set out at paragraph 49. And in that, it is said, Mr Munim says, he did not agree at the meeting that the shares had been taken away without knowledge or consent. Most of the discussion centred around salary and car, and indicated that if all went well, then Mr Rahman would get a raise and a car. And again, we see the judge preferring Mr Munim's recollection about those points, which is the meeting that immediately followed those emails. But all of these paragraphs are relating to the matters that bookended those two April emails, and it also identifies and quotes from the two emails. So plainly, the judge had them very well in mind and weighed them up against the balance of all the other evidence out there. And we've seen that the way that he weighs it up is to acknowledge that on the face of some of the words, it appeared that it could be said that Mr Rahman didn't recognise at that time that he had a 10% shareholding. That would be a point in his favour. So it's recognised by the judge. And that can be seen at page 65, at paragraph 73. And then at 75, of course, we have the conclusion. And the conclusion is, well, there are these two other ways that explain it. And plainly, those were preferred by the judge. Either he simply was genuinely confused at that time and made a mistake in his email, or else he was deliberately suggesting a position to improve his position. He wanted to make it look as if there hadn't been the intermediate position, because then it would make his arguments that that had never happened easier. So all three possibilities of those particular possibilities were floated in the judgment, effectively. They were in the judge's mind, and the balancing process led the judge to conclude it was one of the two latter ones, and that notwithstanding that email, the finding about the stock transfer forms would remain. That was going to the third ground. Sorry, the fourth ground. And the third ground was in relation to Mr Munim's credibility. And on that, there has been so much set out in the skeleton arguments already, and the transcripts show that there has been an awful lot of evidence that was raked over, and it's simply not possible in my submission that there could ever be a challenge on the judge failing to take account critical evidence about credibility. In this sort of case, it doesn't go anywhere, and I don't intend to address the court any more on that, so as to be more efficient. If you would just give me one moment while I check some of my other notes.
Of course.
Yes, I won't be long. But one is...
You've been extremely economical. Take your time.
Within my skeleton argument at paragraph 29, which is at page 43, there was a response to shares being watered down. This is a criticism that the judge, on part of the appellant, had failed to address why that should be the case, and that's a reason for challenging the findings in respect of, for example, the resolutions. But here, it suggested that it was clearly evidenced, because this was relating to the intention to get further investment in the company. And this was put to Mr Rahman in cross-examination, and I very quickly take you to 255 within the supplemental bundle.
Can I just clarify? As I understand it, the shareholders' agreement, as you said, recited the previous, what your case is the previous shareholdings, including 5%.
Yes.
But also then set out what would be the revised shareholdings following
Exactly.
this subdivision and further issue of shares,
Yes.
leaving the 2.5%. Is that correct?
It is correct, and I can take the court to the document. We have the relevant extract. I think it's 46 within the supplemental bundle.
That may be the signature page.
I think it starts a bit early. So page
39 is the beginning of the employment contract.
I think it's page 43.
I think so.
40 and 43, yes. So both of them are extracts of the documents. 39 is the beginning of the employment contract with the signatures on page 41, which signatures were before the expert. The document at 42 was not before the expert, but the judge considered it, and that's an opt-out from the working time regulations. And then at 43, the shareholders agreement, which was very much contested within this trial. And at 44 is Schedule 1 showing the initial shareholders, and at Schedule 2 on 45, the new proposed structure. At 46, then are the various signatures. And about a third of the way down, we can see signed as a deed by Hafiz or Rahman in the presence of Saeed Umar Ali. The signature's on the right-hand side. And all of the signatories have their signatures on the right-hand side. And I understand that the challenge about whether this, in fact, might be a valid deed is because the signature of the witness is missing in respect of Mr. Aziz's signature. We can see that there are 3 Syed Umar Ali's, whereas there are 4 separate signatories. If that were, in fact, capable of rendering any invalidity in respect of this deed, in my submission, it would never affect the deed as against Mr. Rahman when it came to an estoppel point. And I argued, in fact, that it was not a good point in any event. But there is no finding about that within the judgment that we have.
Apologies, I
Not at all. It's a document that I should have taken you to already. At 255 was the reference in the transcript to understanding the framework for why there was going to be the second restructuring. And at E is the question, and you also knew it was the position, because that was the original deal. He was going to facilitate more money going in exchange for your original share transfer, and you signed one of the written resolutions that supported that. And over the page at 256, at the top of the page is, and then let me move on to the rationale for the second restructuring when the company had its shares subdivided, re-registered as a PLC, and then there was an allotment of many shares. That was to get money into the company, wasn't it? Do you agree with that? As far as I know, this grant thing from the government's the ELS, he responds. And then there is more about that, middle of the page, about F. Again, it said to get more investors in, to get money in, because it was needed. And then the exchanges carry on 257. And in my submission, what they show is a slightly begrudging acceptance by Mr. Rahman that, yes, that's what it was to do with, and he recognised that it was so that those shares could be sold to investors who would then take the benefit of the EIS tax relief, and that was a way of improving this matters for the company. That's, of course, relevant to those resolutions because there was no challenge below about the second restructuring. There was no problem raised about that. It was dealt with in the skeleton arguments in case it was pursued, So it was put that these were proper purposes for a director to pursue to get money into a company so that it could work more effectively. And if that were the motivation, then that wouldn't be impeachable, because the alternative, if it had been done to dilute someone's shares wrongfully, would be for an improper purpose. And so that was explored there.
Okay, but what was an issue was whether the shareholders' agreement had been executed by Mr. Rahman.
Yes.
But that isn't appealed.
That is not appealed.
Okay.
And it makes part of the rationale for why he signed it and knew what it was about is because of the rationale he understood in respect of the EIS relief. And that point then also relates to what would happen if the appeal were to be successful. There would then have to be a retrial to deal with the various issues that were not dealt with by the judge. And some of those issues include matters of causation. For example, what happens with the second restructuring? So if there had been a reimposition of the shareholding as they were originally, then it would have been argued that they nevertheless would have been diluted because of the exercise of proper purposes that would have been done in any event to get money in. And those matters were simply never grappled with below by Mr. Rahman. And that, in addition to the other points, would be a very strong reason to be extremely reluctant to reset the clock and to have all of that to come back.
I think your instructing solicitor is trying to give you some instructions.
Will you please
Yeah, of
excuse me
course.
for 1 minute? I have nothing further from that, but if there's any specific issue that I haven't addressed, I would be very grateful for the opportunity to deal with it if there's something that is in your minds that needs to be looked at. Thank you.
No, I think the combination of your submissions and your skeleton argument covers everything. We're very grateful.
Thank you.
Anything in reply?
Just make 3 points, hopefully quite quickly. The first was in relation to some cross-examination transcript that my friend referred you to. So in the supplementary bundle, he referred you to page 317, which was part of the cross-examination of Mr Munim and about the stock transfer forms. So at the top of 317 at A, Mr Munim is saying, yeah, on that I did not physically get the form from Mr Ahmed, I did not physically give it to him. Mr Rahman, who's the middle person who dealt with it, what Mr Rahman gave me, I believed that's what it is, but beyond this I can't comment. And it talks about Mr Ahmed's email address. And I think my own friend, I don't have the exact quote from him, but he said something along the lines of there's nothing here was put to Mr Munim that he'd made anything up about stock transfer forms. That's true, nothing here. However, I would just like to highlight 2 other parts of the cross-examination. If we can go to page 323 at G, question to Mr Munim. the documents included, so, sorry, they're talking about some documents. I can't quite, I think this was,
This is the next year.
yes, I think this might be some documents that Mr Rahman said he was given to sign the next year. So I think my friend's right about that. So what the question is, the documents, including the documents that Mr Rahman was given on 28th of October 2015, those included blank pages and signature pages, but no contracts were attached to it. Do you accept that? Mr Munim says, I did not see the envelope and I do not believe that to be true. So I think these are documents Mr Rahman said the solicitor had given him. And the question is, and you used Mr Rahman's signature on those documents to fabricate the stock transfer forms as well as various resolutions, didn't you? Absolutely not. So clearly put to him the suggestion that he was fabricating signatures on the stock transfer forms. And then again at 328, at the top of 328, there was a final question just to make sure that Mr Ahmed's case had properly been put. The final question, just to make sure I put my case, the reason there are so many irregularities of the documents we've looked at is that you fabricated things to make it look as if Mr Ahmed and Mr Rahman consented to transfer their shares to you. Is that correct? No, absolutely not. Mr Rahman brought this form into me along with Mr Ahmed. Just to be clear, it was clearly suggested to Mr Munim in no uncertain terms that he had forged signatures. Second, just briefly, my learned friend has referred you to the shareholder agreement, said if you look at it, it says that there was initial shareholding of 5% on Mr Rahman and he was going to go to 2.5%. He's referred to estoppel by deed being pleaded. Just in respect of the reply to that pleading on behalf of Mr Rahman and Mr Ahmed, in the core bundle, page 109, my learned friend may have actually quoted this to you earlier, but it's paragraph 19. There's a denial that estoppel by deed applies without prejudice to the defendant and third party's position that the shareholders' agreement is not a valid deed. Estoppel by deed does not operate where the deed is tainted by fraud. Here, the claimant caused the defendant to sign the shareholders' agreement by misrepresenting its nature. Paragraph 30 of the amended petition is repeated. This assertion that there was a misrepresentation of the nature of the shareholders' agreement does not appear to have been dealt with by the judge in the judgment. The judge makes no findings as to whether there was a misrepresentation of the shareholders' agreement. He doesn't appear to address estoppel by deed. So he hasn't really engaged with this because he's reached some initial findings which deal with the matter, particularly the stock transfer forms. He appears to have taken the view he doesn't need to engage with this, but this has not really been dealt with. And the reason ultimately I say goes back to the initial problem with the judgment, which is the findings on stock transfer forms. My learned friend says all I've really got to go on is Mr Ahmed's forms and then an issue about 2 paragraphs in the judgment as to whether they're perhaps confused thinking as to whether the forms were signed or not and whether Mr Rahman saw 5% on resolutions. In my submission, it's not just those 2 points. It's also ground 2 and it's also ground 4. There are other documents where signatures are in question, ground 2 on resolutions. There's also the emails from April 17, which I say the judge hasn't fairly dealt with. These all feed back into the overarching question of whether the agreement, the stock transfer forms were signed, and also whether there was this underlying agreement. It would be very unusual to find, well, the forms were all forged, but there was still an agreement to do it. Why would they be forged? The reason they'd be forged is because there was no agreement to do it in the first place. Unless you have any specific questions for me, I don't propose to trouble you any further.
You said 3 points.
Yes, so the first one was just
Oh,
about
was that the third?
cross-examination. Yes.
Melded into each other.
Sorry.
No, not at all.
First was
I just wanted to make
cross-examination,
sure you had
second
your
was shareholders' agreement and estoppel by deed, and the third was I don't just have 1 or 2 points, I have
You've got the
all the
global
points go
point.
together to an overarching point.
Yes. So your totality of your grounds make up your submissions that the judgment must be overturned.
Yes, so if one didn't alone, if you add them all together, then yes, they must do.
Thank you very much.
Thank you.
Well, thank you both very much indeed for all your submissions. Thank you for sitting over the short adjournment, everybody, and also for us not being able to start. It was due to other commitments amongst the Constitution. So we're very grateful that we managed still to be able to hear the appeal today. We will hand down draft judgments. You won't be surprised to hear we're reserving our judgments. in due course. They'll be handed out in the normal, out in the first instance in the normal way for typographical and other minor infelicities, but not to re-argue the case, please. I'm sure you will each advise your instructing solicitors and your lay clients about the terms of the embargo, which now appear on the draft judgment. Any other matters we'd hope can be dealt with in writing and in due course that you can agree an order. I can thank those behind you for the work they've done in the preparation of the appeal.
Could I just raise one point? I recall that my learned friend's solicitors will be submitting to the court some additional resolutions which aren't in the bundles.
Yes.
Which you will, of course, consider. I just wonder what, if either party has any comments on those documents, specifically
One
raised those
sheet of
documents.
A4, please, exchanged between you before it comes to us.
Right, thank
But
you.
that's not encouraging you to do it, because I think it's highly unlikely you'll need to. But if you need to, of course you must, given that you've not seen them.
Right, thank you.
Very well. Thank you all very much.
All right, are you able to?